Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal education content, and today will be the day I earned that subscription. For today's story, we are talking about the day that was May the 25th in Johnny Depp Amber Heard land. Yes, it is the second to last day, my friend. It appears we only have one more witness for Johnny Depp's case tomorrow, which presumably is the airplane attendant, which should be lots of fun. And then we get a rebuttal case from Amber Heard, but not much of one because she only has an hour and 15 minutes left for everything. So presumably they may burn some of that time for the attendant, and then I don't know, because they have an hour and 15 minutes left, which is enough time to call one, maybe two witnesses if you're being really efficient about it. But, Amber Heard's team's not exactly known for their efficiency. I mean, strictly speaking, you can do directs in less. We saw a very fast direct today by Johnny Depp's lawyers in the form of Kate Moss. She was on the stand for what? A total of 5 minutes tops? Get in, get out. No cross-examination, no redirect, So, hey, it can be done. If you only have a few questions, you can do a direct in 5 minutes. But I don't imagine that's going to be the case today or tomorrow for whatever Amber Heard wants to do. I'm thinking it's going to take a little bit more time than the 5 minutes. So I don't know what they're going to do. Well, they only have an hour and 15 minutes to do it in, whatever that is. So, good luck for them on all that stuff. So fun. But we're going to try to look at all the things that happened today. So let me just quickly pull up an article that will describe the names of all the witnesses, because then it helps me remember who all the witnesses were so I can talk about them intelligently. Hold on. All right, so who testified today? Let's get a list. Let's see. That's a day ago. That's 2 days ago. I need something from today. Oh, my word. I need today's list, please. Sort by date. I need past 24 hours. Okay, NBC News, I think, has me covered. Great. All right. Fantastic. All right. Did I remain the stream public? I think so. You guys should be able to tell. If it's not, it should say if it's unlisted or public, but hopefully it has been made public. All right. So let's see. Who did we have today? So we start the day with Kate Moss, which lasted all 5 minutes. We got in, got out, I slipped on the stairs once because it was raining really, really hard. And I cried out in pain. And Johnny Depp took me to my room and made sure I was okay and got me medical attention. That was good. Yes, everyone, please remember to subscribe. As always, appreciated. Thank you. So that was quick, to the point. Then we got Dr. Curry, who is a fantastic expert witness. She is one of the best expert witnesses I have seen in quite a long time, in every possible sense of being a great expert witness. Like what Camille is to cross-examination is Curry as to being an expert witness. I mean, maybe not quite in that territory because Camille is on God land, but Curry is just exceptionally good. So I don't know if she's quite, putting mortals before her, but she's really, really, really good. She's really good for a couple of reasons. First of all, she knows her stuff, which you would hope them all do, but she's able to communicate it in a really relatable way. She's able to talk to the jury while keeping it understandable without talking down to them, which is a tricky mix for an expert, because you want to be able to tell them things that are complicated things, and you don't want them to feel like they're talking down to you at the same time. So that's a really tricky mix, but she has that done. She has it well done. And she's also really good in handling the questions she's getting and giving the answers that they want in terms of getting them out efficiently. And on cross-examination, she's also really good in having the right amount of pushback. Because again, you could go with the no pushback approach, which is a valid approach. And if you're going to go like on one extreme or the other, I'd much rather you have the no pushback approach, because I can fix it on redirect. if you're my witness, right? So if I have to choose, I'll choose the no pushback approach, and I'll try to fix it on redirect. But she has a good amount of pushback. She has the right amount of pushback to seem like she is answering the questions without seeming like she is being obstinate or difficult. So she's really, really good at that balance. She's pushing it a little bit parts, but I don't feel like she ever crossed the line. So, she's just really able to handle it, keep on focus, make sure she's giving out good information, push back a little where she has to, and she's able to do it in a really endearing way. So she's a really good witness. And of course, as to the substance of her witness, no, am I out of focus? No, I'm not. My background might be, but that's because of the bokeh. But I'm not out of focus. I'm perfect. Yeah. Put my subscriber number on screen. I guess I could do that, but it's not going up that much. Anyways, let me finish my thoughts. Okay, as to the substance of the Dr. Curry, I thought she did it very good in terms of addressing the witnesses that were used against her. And she did a really good job in showing, at least to her, and she came off again very credible about showing why a lot of these tests were inappropriate for this setting. Why these were not good tests or not applied well, and how she applied her tests and how her tests were mischaracterized. So she did a very good job, again, in contradicting another expert in a relatable way without seeming defensive. So she has that really locked down. She's really, really good as an expert witness because she's able to come in and say, no, they got it wrong. They got my wrong. Defend her ground without seeming defensive. She's able to push back without seeming obstinate. She's able to answer questions without seeming that she is talking down to people. This is a difficult combination for anybody. Dr. Curry has it really well done. And it was really, really good as a result. So I thought, if you're ever interested as an expert witness, if you ever have the occasion to be called as an expert witness, I would look to Dr. Curry's all of her testimony as an exemplar. Look at what she's doing. Try to emulate that. I think she's a really good example. And it doesn't matter, by the way, what your nature of your expertise is. It doesn't matter. So it doesn't matter if you're in the psychiatry field or medical field or construction or like literally anything else. Dr. Curry is still a really good model to follow. If you can figure out how to give information, because if you're an expert, you're an expert, right? I mean, I'm not saying anything to talk down to anybody. If you're a construction expert, you're a construction expert. If you're an accident reconstruction expert, you're an expert in that area, right? So whatever your area of expertise is, you have a lot of information to share. So you should figure out a way to give the information like Dr. Curry did. Be relatable, give them information that respects their intelligence, doesn't overwhelm them with undue technical minutia, doesn't talk down to them, where you don't push back against the other side's attorney, or if you do, you handle it in a very moderated way. She's a great example of an expert witness. So if you ever have the occasion to do it, I'd use her as, mastery means simplicity. Yeah, that is one of the true keys of mastery, right? The master makes it look simple. Yeah. So it was just very positive. Johnny Depp returned to the witness stand. Didn't really do much for me on any level. I don't think he really lost much ground, if any ground, but he didn't gain any ground. So I guess on balance, he was a disappointment. We would have hoped for more. Because he was so good initially as a witness for his own side. So he was really positive as a witness, really charming, came off well, affable, relatable, and all the rest of it. And so the idea would be, well, it worked so much the first time, so let's have it again. But it didn't really work in repeat. It wasn't like bad. It just, Dr. Curry was good both times. So I think a good example can be shown between Dr. Curry both times versus Johnny Depp both times. Dr. Curry was able to give the same quality performance the second time as she did the first time. It was as good the second time as the first time. And she had to do more in some respects because she had to also like address ground that had been lost. So she had more to do, and she was able to do it really well. So Dr. Curry, from the first appearance, the second appearance, very consistent, very relatable. She didn't lose any ground. She gained ground both times. She did really, really well. It just goes to show how great she is. Johnny Depp is not in this category, in my humble opinion. Johnny Depp was very, very good the first time, but to my mind, it wasn't as good the second time. And I can't point to anything specifically about why. I mean, except to the extent we'll talk about stuff that happened during cross-examination a little bit. But, you know, it's in my mind, it just didn't really have the same impact. It didn't really have the same je ne sais quoi that we saw the first time. So, you know, he talked about Waldman. I was scared out of my mind when they started asking questions about Waldman. I was terrified because that is really, really dangerous territory. Because Johnny Depp can waive the attorney-client privilege, right? So that they haven't been able to ask about what he told Johnny or what Johnny told him because of attorney-client privilege. But Johnny Depp can waive that privilege because he's the client. So I was terrified out of my mind he was going to say something that was going to open that door. I was terrified he was going to say, well, I told Walderman, or Walderman told me, or something like that. Anything like that, that could open the door. Fortunately, and thank God, he didn't do anything like that. He didn't open the door. So I had a very visceral panic attack as I'm watching this, thinking to myself, this could go really south really fast. Fortunately, that didn't happen. So, you know, bullet dodged by all of us. But he says, you know, that he never saw the statements before the lawsuit happened. You know, and you let implication do the rest. So, yeah, you know, okay. Yeah, so all the rest of it. Don't insult other people in chat. It's a rule. You know the rules. If my mods are out there, remember to time people out if they're rude to other people in chat. Don't be rude to other people in chat. Okay, so we heard about, we heard an incident. Nate the lawyer's in the backstage. I'll let him in just a second. I'll finish my thought first. Nate apologized that Johnny Depp said that Heard hurt him with this Orient Express trip. The photos weren't particularly persuasive, and they were able to somewhat contradict that as well. So I didn't really think that that really did very much for him. We didn't really need the idea that Amber Heard was physically abusive. We kind of already had that. We didn't really need to point out more. And so it was a little bit weak sauce. At this point, I'd like to introduce my guest, Nate the lawyer. Hello, Nate the lawyer. How are you?
Hey, what's going on, bro?
Not much, man. We were just talking about the day that was, and we were talking about Johnny Depp. So far, we're still in the direct of Johnny Depp. And I was pointing out that, at least to my mind, while Dr. Curry, I thought, was really, really good on both occasions she appeared on the stand, to my mind, I didn't think Johnny Depp was as good the second time. It's like, I can't really put the reason why, but it didn't quite work for me.
Listen, unless we get some type of miracle, there's no way I think you can reasonably look at that cross-examination and think it went well for the client, right? I'm saying, you know, there's people just on technicalities alone. Depp kind of got killed. Whenever a lawyer says, isn't it true you said, and they quote a statement, and you say no, you should be prepared for one or two things. They're going to either move on to the next question or going to say, well, didn't you give a deposition in this case earlier in this case? And weren't you asked, you know, give you the date? And on that date in question, you were asked the question. And this is what you said. And it's not going to be the same as what you just said right now. So he fell into that trap hard because they brought up the text messages. Now, I know there's some issues going on right now with the text messages. Some people said when you look at them, they said incoming versus outgoing. That's the case. They got to clean that up because right now the jury out there thinking that those text messages belong to Johnny Depp. And not only do they belong to Johnny Depp, they so damning that he himself had to deny them. Even when presented, here they go. He said, they not mine. They not mine. That's what I saw today, just to be fair.
Yeah.
Maybe other people didn't see that.
Yeah, I mean, to the extent the incoming versus outgoing thing would make any difference at all, the difference was not brought to the jury's attention. No one at any point said anything like, well, if you see that these messages are marked incoming versus outgoing, and therefore that means blank. So this fact was not really elucidated from the testimony. So I mean, there might be some people in the jury who are quite smart and technologically savvy. I mean, this is a fairly young jury, so they might look at that and draw some conclusions. But again, one of the many problems, of course, is that this is such a long trial with so much evidence and so much stuff that I wouldn't expect the jury to pick up on any particular nuance. Even if it had been brought to their overt attention, I could understand them losing the plot, because I've heard things that I've lost the plot on just because I'm tired and been doing this a long time. So, all that stuff. But, it really wasn't drawn to the jury's attention. So I think everyone in the chats who's making a thing of this ingoing, outgoing, I think they're somewhat making a mistake. Because, I mean, the jury doesn't know any of this stuff, chat. They only know what they heard. And so you're stuck with that.
Yeah, because I see it out, but it's like, I think the only thing they got going on now, do I think that's enough to win the case, even if taking it in the worst possible sense? No, I think Johnny's still up. I think it's still his to win. It's like if I'm analogizing it to soccer, he was up like 5-1 and kicked an own goal, right? So now it's 5-2. So I don't think he's, and we got a minute left in bonus time. So it's over. But what I do think is that they should have there should be no more forced errors. I don't know what you got from Depp, and maybe this is the question for you. What did they get from Depp today that made their case better? Because that's why you put him on again, right? You put him on because he's going to give you something to make your case better, make your case stronger, make a better presentation. What did you get from him today? Or what do you think you got from him today that made their case better?
I don't think you got I don't really think you got anything from Depp. I don't know why you put Depp on the stand. I mean, he echoed Amber Heard's comments, but I apologize. Kate Moss's comments, but why? Like, they just heard it from Kate Moss just now. There's like no need to refresh their memory or something. So I don't know why you put him on the stand. I don't know that you got really anything of value out of Johnny Depp from the testimony today. I mean, there was some stuff dealing with Whitney, because the chat reminded me about that. So there was that aspect. So I'll give him a point there. That's fair. Where he was able to, say without any chance for, Whitney to rebut it, that, that she was basically abused too, and basically yelled at and all the rest of it. So just make her Amber Heard look like more and more of a monster. So it was good because it was one of the more solid things that would help to discredit Whitney in some way. So that was positive.
Yeah, that's true. That's true. But I don't know. I think at the end of the day, if you take everything into account, it was maybe a wash, right? It wasn't that wouldn't be like the reason why I would put him on for that cross. If I knew the cross was going to be like that, I kind of like, you know what? I'll just keep you in the keep that that bullet in the gun. We're not gonna unload that. But yeah. I also think they're so far ahead where this really won't matter.
No, I agree.
I think when it comes to Amber, that it's just so much overwhelming evidence against her. It's like it's really just comes down to that, and I think her team, like even like they got TMZ guy, and I do want to mention the way
we haven't gotten that far yet. We haven't gotten that far yet. We're doing it in order. We're still on Johnny Depp.
Okay.
That's how I roll on this. Just do the witnesses in order. So we covered the direct. We covered cross-examination a little bit. Let's talk a little bit more about the cross-examination of Depp. Again, I don't remember if this is on direct or cross-examination. The stuff about the lighting issues, like with the photos of the Orient Express. And he's like, oh, the lighting issues. It's like, It's like, I mean, come on. It just felt like a little forced. It felt a little inauthentic.
No, there's a lot of grasping at straws right around there. I think they were again they're shooting for a Hail Mary and they just literally got a final shot, right? Hey, here's Johnny Depp again on cross, just in case you didn't get enough of the first time, right?
And then on redirect,
except there's just less time, so just okay, I'll take another shot.
So on cross, he wasn't really great because Amber Heard's lawyers were able to effectively bring in these text messages, and Johnny Depp looked evasive. And then also the redirect seemed like a mistake because even though there was a question or two about the UK trial in the cross-examination, it felt like the Johnny Depp own team was bringing in way more information about the Sun trial and stuff. I was like, I don't know why you're asking so many questions about this. You're bringing in all this information. Now, Johnny Depp had some good answers there, to be fair, because he was able to point out that there are different laws with a different system and different evidence, and also point out that it was the Sun that was the other party versus Amber Heard. So, I mean, it wasn't a total loss, but it felt like so many questions were being asked about the UK trial by Johnny Depp's own side. I was kind of like confused.
Yeah, I think sometimes this trial can be a PR war too. Yeah. Because don't forget, when Benchu gets up there and the first half of his argument is addressing counsel's legal arguments, and the second part, he starts going into, Amber's a horrible person, like that type of stuff. It's obvious they're playing a PR game too. So I think both sides are doing it, and we'd be naive to just believe that it's just coming from one side. But one thing I do think this case is really just put forward is that Johnny Depp has the facts on his side, and that wins the day, right? The facts actually win the day. And the fact is that Shannon Curry says that Amber is histrionic, and Amber exaggerates these things. And that seems to be consistent with the type of story she's telling, right? My nose has been broken. This. We don't see anything. Yep. You're exaggerating, just like the Dr. Curry predicts.
Absolutely. Dr. Curry was an absolute star. I already talked about her, but she was an absolute star. She was very, very effective. So I think Johnny Depp himself was a bit of a loss for the Johnny Depp team today. I think he, again, trying to put this all in perspective. But
so you thought it's more of a minus than a plus?
I thought it was a minus putting him on stand. I thought you lost a little ground by putting him on the stand. He came off, to my mind, as a little bit evasive. He helped to contradict the Whitney story, so that was some positive stuff, but a lot of the UK stuff came in that wasn't really great. So I think on the whole, calling him was a net loss. I mean, it's not a huge net loss. I didn't even at the time have a huge reaction to it. When I was on with Legal Bites, a lot of the people were really, really worried about it. I didn't feel that way about it. And I still don't feel that way about it. I think it was a net loss, but again, there's so much going on for him that I wouldn't worry about it too much in the grand scheme of this thing. It was kind of bad. Maybe it's just exhausted, maybe a whole bunch of things, but just try to evaluate it on its own terms. It was a net loss, in my humble opinion.
Yeah, I can see how you get there. See, I think it's just flat. I think he was just winning so much. He was still charismatic on redirect, and I think the rehabilitation did enough to put you at least back at even, right? It did. I don't think it made it a major win. Like, oh yeah, he killed it, but I do think it was enough to put him back at even because he answered some of the questions.
I wouldn't go that far about putting it back at even. I wouldn't go that far.
Yeah, I don't know. I got him back at even.
Wow, I mean that's a very skeptical look. I mean, I don't think it's been anything close to even for quite a long time. I mean, even in my doubts, I'm over at like 70%, and the rest is not.
I'm talking about just the Johnny Depp testimony. Oh, like whether it was worth it or right. I'm saying you were saying it's less than 50%. I'm saying it's even.
Oh, okay. All right. Yeah, I think it was less than 50% then.
Yeah, I'm saying it's even. I think it was about 50-50.
Yeah, either way, we're not disagreeing by much. I thought you meant the overall trial. I was about to have like...
Oh, no, the overall trial. I think he's like at least 70-80%. Yeah.
Yeah, absolutely. All right, so the next witness on the stand was this guy, Brian, the Exif guy. he was pretty good. His answers I know what he's talking about. And so I think there's a pretty decent chance that there are a lot of members of the jury who do too, because you remember this is Fairfax County. It's it's a suburb of DC basically. There is a lot of very intelligent people that live there, defense contractors, government employees. It's a high tech corridor of the country. It's one of the richest parts of the country as a result. So I think a lot of people might have had as much knowledge as the person testifying. Nevertheless, it was good to show that these videos and photos had been, well, if not necessarily manipulated, they had been there were different versions of them at different levels of resolution, and there were two different photos that were just basically the same photo with different level of saturation. That was a really nice little moment there with the photos overlining.
Well, hold on. Didn't you skip TMZ guy?
TMZ guy was later.
TMZ guy. The TMZ guy was before the other guy. Oh, all right, cool.
Well,
you're probably right. I probably got it mixed up.
Maybe TMZ guy was first, but we'll do it. Well, let's talk about Exif guy first because I have him first in my notes, or first in this I'm looking from. Let's just talk about Exif guy, then we'll go back to TMZ guy.
All right. So which one? Which guy was this? This was the What did he testify to again?
He was testifying that the photos metadata.
Oh yes, the photos. Yes. The problem. All right. So his testimony to me was good on direct because it was kind of simple. Here's a video. Here's the overlap. They all messed up. I don't know nothing. Blah 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 blah. The cross of that guy was a little bit. It was interesting because it seemed like the cross examiner was someone new who we haven't seen. Mm-hmm. So his style was a little bit more abrasive, and he was trying to control the witness, and even control direct, which he kept saying, that keeps happening. So I liked it. I like that that he brought a different energy to the room. I also thought he was very competent in what he was doing. He was very competent, and the back and forth between him and the doctor were good enough where he cast doubt a little doubt with the whole, hey, you don't really have any academic credentials. Your degree is in political science 28 years ago or whatever, 40 years ago, I think he said, 40 years ago. So, those things were nice little hits. But I think overall, when the doctor kind of showed you like this is what it is and played those overlays, at that point you got to believe your eyes, right? You're not gonna, no matter what he's saying, he's showing you like, here, look at it. This is exactly what happened. So I think that data, for me, data, facts, and evidence trump conjecture. So I think the doctor, when they showed those overlays, those were facts and evidence. Like that happened. So whatever they say counter to that, it's got to be better than that because the doctor's showing me that. You just talking about stuff.
Absolutely. Yeah, but what he's really good for is not really so much in what he said, but in getting the idea implanted in the jury's mind that these photos are manipulated, inauthentic, that they're not originals. So he gets in the whole idea of these photos not being truly real, which is great because they already have lots of reasons to doubt Amber Heard's testimony anyway, and now they're hearing testimony from somebody saying, hey, wait a second, there's some evidence here that suggests these photos are not exactly what the camera took. Yeah. And so, there's that.
They're lightened up. You're using different programs. Yeah, we don't got no originals. But I do like the part that the witness was hammering home. And that was, hey, no expert can verify these. No one can verify. They kept saying, so you can't verify it wasn't Amber. He was like, nobody can verify anything about these. That's how it is. No one could do it. It's an impossible task.
Yeah, well, because he was asking for proof of a thing that doesn't happen, right? It's proof of the negative. That's a pretty much borderline impossible question to ask. It's like I show a book on your shelf. Prove to me you haven't read it in the last week. It's like, how, right? It's basically borderline impossible. So he's trying to evade it because it is an unfair question. It's like you didn't find any proof that they weren't manipulated. It's like you're asking me an impossible question, so I'm not going to answer it. So I thought he did a fine job trying to resist that because it's a ludicrous question. Like no one can do this. Prove a negative. Not really. No. So yeah. So finally, I guess that brings us to slightly out of order on the testimony of the day. TMZ guy, who was a delight.
Yeah, TMZ guy was good. TMZ guy. I liked him getting his direct was well done. I think some of Elaine's objections were kind of misplaced. Like she was saying hearsay a lot. She got a couple of those in, but a lot of them were just like, what's he talking about? She's just yelling hearsay just to break some flow.
Yeah.
But again, I think Elaine, and as you can see, when time is tight, you go right back to the fundamentals of cross-examination, no matter who you are, no matter what you do, no matter where you practice. When you get tight on time, you go back to the fundamentals because that's what works, or no matter what the situation is. And it's the most efficient way to cross-examine a witness. And that's what you're seeing the defense do right now under this time pressure. Only leading questions, know the answers to the questions, have everything prepared, go get in and get out, right? Hit only the high points. How many commandments of the 10 commandments of cross-examination are they hitting, Kurt? Every day.
When they're constrained on time, they're doing better. And this goes this whole idea from art from adversity, that constraints can produce a better product than unlimited budgets or unlimited budgets of time or money. It's like that constraints can produce a better product. And that's often true. But what was great for this guy is like, because it's hard to imagine that he actually violated whatever NDA exists. Based on his testimony. Like I haven't read it, but it's hard to imagine because he's basically just talking about like standardized process.
Yeah.
So he's like, okay, like I'm a middleman for the field people and operations. Great.
Yeah.
I deal with dispatching the paparazzi. I have this many paparazzi who work for me. Fantastic. And so then we ask a whole bunch of operational questions, basically. It's like, okay, do you guys like normally go to courthouses? No, not really. Not really a place we expect to see anybody. We're not going to go to that location. Are you normally at this kind of location? No. Are you normally at this kind of location? No. Okay, great. So how is it that you go to these kinds of locations if it's not places you normally go? And it's like, well, we have a whole process for this from tips. And we have a process for vetting tips. How long does it take to vet these tips? Well, it depends on the source of the tip. Which is a perfectly reasonable answer. It's what you'd expect. If it comes from the principal or it comes from like one of their agents directly, more credible. If it comes from Rand on the street, less credible. We have to vet it a little bit more. All right, so we go through the process. How long did it take you to vet these particular ones? It didn't take us very long at all to vet those particular stories. So like he doesn't know, he can't testify who it came from, but he can testify to the process. It's like the process was relatively short, which leads to the implication it came from one of these people, right? And then you have the question, okay, how about the content you guys use? Like videos and photos. So it's like, well, copyright's a big deal to us. We want to make sure we have the copyright in it. And so we want to make sure that we have the authorization. And so how long does it take? Oh, again, it depends. It depends who we get it from. If it comes through, unspecified channels, that can take us quite a bit of time. If it comes from the direct source, sometimes it can be 15 minutes. Yeah. Okay. How long did it take you in this case? It took us about 15 minutes.
Yeah, that was
so like he doesn't know who's on the other end of that, so he can't testify to that. But he's like, well, if it comes from a direct source, it's 15 minutes, and this was 15 minutes. Therefore, what is the natural implication of it? It came directly from Amber Heard, right? Why were you at that courthouse? The implication is it came from Amber Heard. So he was able to say all these things because he doesn't know where the source was because it came from anonymous things of a Dropbox and blah, 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 and all the rest of it. So, he's able to just lead this to by implication. And it's hard to imagine that violates any NDA. because again, I mean, I haven't read their NDA, but he's just talking about generalized process.
Oh
So like,
yeah,
what is your
yeah, yeah.
what is your kind of process you use? All right, okay, this is kind of the process we talk about.
Well,
It's like, yeah.
well, sometimes that could be methods, though, right? Methods of practice. So I don't know.
Yeah, one thing you want to say, like trade secrets, but it's like, I
At
mean, there's
trade
probably
secrets, but it may not be a process that everybody uses. I don't know.
it's
I'm maybe
probably
just
something
stretching
that
it.
anyone who's in the trade could conjure without knowing. Because I mean, everything he
That's
said to
true.
me everything he said to me, like I'm not in the trade, but everything he said to me sounded like wrote obvious once he said it. And so I'm like, well, if I have
Yeah,
any experience
yeah.
in the trade, I'm like, I'm not telling you anything you didn't already know. So
All
I'm like,
right.
okay.
Yeah, yeah.
So, anyways, he was really good at getting this implication in without having to say anything that probably didn't screw him over.
Yeah.
Then on
I think he was good.
cross-examination, we got some of the best moments of the trial. We have to also go back after we're done with
Yes.
this. We have to talk about TMZ lawyer guy before we get to TMZ guy. So we have to go back to TMZ lawyer guy, but let's stick with TMZ guy for the moment. We got some of the best moments in the trial because, we got Elaine up there asking about his 15 minutes of fame, and he had such a great answer. If he came up with that on the fly, it's like, well, bravo for you, man, because he just gave a really, really great answer about, I don't really want the fame. In fact, if anything, I'm putting myself at some sort of legal exposure. Great answer. Do you want to put it on screen again? You want to play it?
Damn right. Let's do it, baby.
All right, let's see the moment again.
He was being kind of talked about in this trial, and so I had seen a clip of that.
So you watched some of this trial?
Correct.
Okay. When did you first reach out to counsel for Mr. Depp?
I believe that was 6 days ago, whatever that date would be. I'd have to do that.
All right. And then you received a subpoena, I think yesterday, in care of your attorney, Cindy Hickox, right?
Correct.
Okay. And Cindy Hickox represents Christy Dombrowski, Kate James, Robin Baum.
Objection,
and Debbie
Your Honor.
Lloyd. Were you aware
Calls
of
for
that?
speculation.
Were you aware of that?
No.
Now, if you don't have information
Tight.
that's helpful to this case,
Tight
then
cross.
you wouldn't be a witness, correct?
Objection.
That's objection speculation for days. He wouldn't know that.
Sustained.
Yeah.
I'm not aware.
Okay, you know this case is being televised, right?
I am aware that there are cameras.
And so
Only
this gives
letting
you your
questions.
15 minutes of fame, doesn't it?
Objection, Your Honor. Argumentative.
I can ask that question.
Overruled.
So I stand to gain nothing from this. I'm actually putting myself kind of in the target of TMZ, a very litigious organization, and I'm not seeking any 15 minutes here. Though you're welcome to speculate. I could say the same thing by taking Amber Heard as a client for you.
This
You're
is
like an
it.
entity, don't you think?
Oh, hardly. I find that to be purely logical. Thank you.
Now, are you aware that Mr. Depp's attorneys were well aware of the TRO that was going to be presented on May 27th?
All right, we can
Objection.
stop there.
Calls for speculation.
Stop
Are
there.
you aware of that?
Lack
Hold
of
on.
foundation.
Yeah. I mean, that's really all we need of that stuff was the intro to that, right? So it's like, yeah, that's just a great moment. And if you watch like Johnny Depp's lawyer's side of it, they were having a lot of fun with it. By the way, I can hear your television in your
Oh,
background.
sorry.
And so it's like, yeah, if you go watch it, you go watch the attorneys for Johnny Depp's side. They're having a lot of fun, and it was kind of hilarious too because she just made this very argumentative question. The objection was argumentative, overruled, and then he gives this argumentative reply, and then she's like, "Well, isn't that argumentative?" So, and then he says, "No, for me, it's strictly logical," which of course it is, and it makes logical sense. So it was pretty good, you know.
Yeah,
So,
know, I know clients stiff on the bill sometime, but I don't know. Do you think like they're making some bones about maybe the legal bill might be tight? I'm like, nah, I don't think so.
Yeah.
There's no evidence of that.
Yeah, absolutely. So let's go back to TMZ lawyer guy for a minute, because TMZ lawyer guy was doing fine. He was doing his job and he was doing admirably, and he did the best he could, which I totally respect. His brief was well written. He cited cases that didn't really cite for the proposition he wanted, but they were the closest authority. And there wasn't any authority, to the best of my knowledge, and no one brought it to my attention, at least. There wasn't any authority that stood for the opposite proposition.
And shout out to Nick. I gotta give Nick a lot of credit. I was watching this coverage on it. He nailed it when he said, "Yeah, the statute that they were pointing to was a criminal statute. Didn't even apply to civil cases."
Yeah.
And the judge can like right out the back saying, "Yeah, this is for criminal cases." It
Right.
doesn't
So
even
they
apply
didn't
to
really
civil
have any
stuff.
great authority for the proposition, which is ultimately why they wound up where they wound up. But they're going to try to argue from extension, which for a lawyer is perfectly valid. You can do that. You can say, okay, here's authority. I want to extend the law. Or even like I want to reverse the law. You can do that. Like if you have a good faith basis for it, you can do that, right? The law says this about criminal cases. It says this about people who are being compelled to testify. So I want to extend the law and bring it into this new context. This is a perfectly valid thing for a lawyer to try to do. So I have no fault with him.
Yeah,
And go ahead.
No, but and maybe it'll be helpful to help people understand why TMZ lost.
Sure. Well, TMZ lost because there is no law that supports the proposition that they're going for. First of all, the entire idea of journalistic privilege in Virginia is relatively new. It was only added by statute in 2018, 2019. So it's a relatively new law. And like any law that's passed by the legislature, it has to be confined. It has to be understood by its own terms, because all privileges are to be narrowly construed, because privileges by their very nature keep evidence out of court, which is not the goal. We want evidence in court. So every time there's privilege, it prevents evidence from coming into court. So like all the people, for example, in the various chats who are saying things like, why can't this piece of evidence, why can't this piece of evidence come in? This isn't really a truth-seeking exercise. Well, privilege is an example of something that prevents evidence from coming in. We won't let you ask questions about what you told your lawyer. We won't let you ask questions about this because it's improper. So, the things that are excluded can help both sides, and the rules are written, of course, neutrally. So anyways, the rules as written deal with the contingency on which the professional wants to keep their sources secret. So basically, the way it comes up in the relevant law is they subpoena the journalist, and the journalist says, and they ask the journalist effectively, who are your sources? And the journalist says, but I don't wanna. And then there is an escape valve in the law for if they are truly like necessary to prevent a perversion of justice, blah, blah, blah. So the rule, of course, written by the legislature is not absolute, and it's not as strict as, for example, attorney-client privilege, which wouldn't go to this level. Attorney-client privilege goes further in protecting more. So anyways, this is not the scenario, right? In this scenario, whoever it is who's testifying wants to testify. So like all that rule doesn't apply. The rule that they cite is a rule for criminal cases. This is a civil case, so the rules doesn't apply. So they're trying to use all this authority for the proposition, well, the journalist doesn't want to testify. And they're trying to say, in so many words, that TMZ as an organization should be treated as the journalist, rather than this guy in particular should be treated as the journalist. It's like TMZ, the rights of this belong to TMZ. They pay the guy. He was our agent. Everything he did was our work product. He is merely an arm of TMZ. And so the real privilege really should belong with TMZ, which is a lucid, reasoned argument, in my opinion.
Well, I think TMZ made a tactical error here.
Mm-hmm.
TMZ's error was trying to get into the Depp case. They should have sued him.
Yeah.
And try to get an emergency order against him to not to disclose. If we have an NDA, I sue you and stop you from giving any testimony until our stuff is heard, right? Because we got an NDA. So I don't know why TMZ would then go try to just jump, because they tried to jump that hurdle by saying, well, we can just go straight to Depp case. But then in Depp case, they're like, well, you don't have anything to do with it. You're too far removed. Mm-hmm. Your beef is not with us. It's actually with him, right? If he's coming here to testify freely, he's doing his own thing, right? So it's unfortunately, I think at the end of the day, today it ended on a really great note, because I think the cop ended it. But matter of fact, I forgot. We're going in order. Go ahead.
No, that's fine. You can talk about the cop. We can come back.
No, I think ending on the cop was really a strong point too. The DV that they're not calling DV. That if you notice, they didn't call her a cop. that was really tailored testimony to make sure you avoided the propensity evidence, and you could clearly see the judge allowed this witness to be a fact witness and not a witness, and not expressed that they were a police officer, nor that they even arrested Amber Heard for that event.
Mm-hmm.
So all that was left out of that testimony.
Yep, absolutely.
And this witness was prepped in 24 hours. So it was kind of like, yo, we're going to talk about this. You
They
can't
did
mention
good.
you're a police officer. You can't mention she was arrested. We just want to hear the facts of the case, that what you saw and what you observed.
Mhm.
You know, she observed her hit her. She observed her rip a necklace off. Those are horrible things, right?
Mhm.
But she never said she arrested her.
Mhm.
So I think Amber's kind of got a little win there, because I think if that jury hears that Amber was arrested for domestic violence in the past.
Uh-oh, we lost Nate the lawyer. Yeah.
I'm sorry. I think her case is over.
Yeah, I tend to agree. And there is one other moment that I want to mention, because it was an uncomfortable moment in the trial for me. We've had two. Well, I've had two moments that made me kind of viscerally uncomfortable so far in the trial. I try to apply my logic brain as much as my logic brain will allow. But yes, I actually do have emotions in there somewhere. And, every once in a while it becomes, too much. And the emotional part of my brain kicks in. When I'm trying to do my analytical stuff, like in my real life, I'm more emotional. But when I'm trying to do my YouTube stuff, I tend to lean more on the analytical, because I think it's more appropriate, but whatever. Anyways, so the first thing that was uncomfortable in this trial for me was on Vasquez's cross of Amber Heard, because we played some tapes from Amber Heard that made her seem evil. Let's just go with evil. Like that one tape, I'm still like having bad dreams about it. Basically, the one tape of her like just basically laughing and mocking Johnny Depp, and just this fake crying, fake mocking, taunting.
They put on a great case, bro. You ain't got to convince us. If you ask people in the chat, I'm telling you, they're convinced. Most people are convinced. If people who watch the trial, if you've been watching this trial, you probably now like, yeah, I think. Like, look at Chris Rock. Chris Rock even said, "Believe all words, but don't believe ever heard." Like
she had a laugh in there, like the chat is noting. It was like the Joker or something.
Anybody who believes in facts and evidence, look at the facts and evidence in this case. You're not coming out to the right conclusion. But it's also interesting to see those people see how the media is treating the story versus what they're seeing.
Exactly
real,
this moment. Exactly this moment. You're gonna put this in your book. You're gonna put this in your book, man. I was not a happy camper. I actually had to turn off the camera and like walk away a little bit, because I was so uncomfortable from it. It's just like I was like not having a happy day, man, on that one. So that was moment number one, where logic kind of left my brain for a minute there, and had to deal with some very uncomfortable feelings, because I tend to rely more in general, although not as much as I am on camera, but in my life, I do rely more on analytics, probably vis-a-vis the next person on the street. And so when I do have to have emotional issues, it's like, well, maybe I'm just not well suited for that, because I don't use them as much. So maybe it's underdeveloped or something, but whatever. Anyways, so that was moment one, where kind of logic left the door. And then moment number two happened today, where logic kind of left the door for a minute, where this is going back to where Johnny Depp was on the stand. And the one good part about Johnny Depp being on the stand was talking about Amber and talking about the sister and their relationships, and how, Amber abused the sister, and so forth and so on. We saw a lot of testimony along these lines. And there was one moment in particular where Johnny Depp was talking about this, and the camera went over to Amber, and she had a look on her face. And I asked the question, Lita's chat, and I asked it very cautiously. But I was like, tell me if I'm looking at this wrong, or tell me if I'm overreading this, because I'm happy if I am. I'm happy to be corrected here. But something about her look and that smile on her face is just coming off as I forget the exact adjectives I used at the time, but coming off as satisfied, coming off as, coming off as pleased, coming off as enjoying it. I guess
She's looking like a Bond villain. She's like a Bond
I,
villain.
I
Huh?
guess sadistic is perhaps exactly the right word here. It's coming off looking sadistic.
They were calling her Dr. No the other day because of the outfit. Or
Yeah.
what's the other one from
Yeah.
She's a
And
Bond villain guy.
so and I said also on Legal Bites, I point out it reminds me, what it reminded me of was someone thinking about an event in the past that was fun, and like having a knowing smile. Like maybe it was like, it reminded me of someone who's recalling maybe something slightly illicit that happened in their past, or slightly like where they got into trouble, like someone like recalling a story that has a little bit of, a little bit of edge to it, I guess would be one way of doing it, and remembering it fondly, and because of like other things that happened. And it had that same look on it. It had a look of positive reminiscence. It had a look of satisfaction, fondness. Someone in the chat suggests fondness is a good descriptor for it. And it made me, this was the second time in trial where I became uncomfortable, because I'm like, man, if I'm reading this right, and I don't know if I am, but it looked really, again, evil and uncomfortable. So this is Amber will have this look on her when Johnny Depp was talking about how Amber had treated Whitney, and it looked, someone said it's called Duper's Delight. I've seen that suggestion before as well, and so it made me uncomfortable.
Well, interesting. I don't know, man. It's weird, because most of the stuff that I found to be most convincing. It's just the way she's telling the story so differently, and just it seems so exaggerated. Like if even if you tell a story, it should be consistent with some of the facts, but things get so chopped up. New facts are all added. Things that she couldn't remember, now she remembers, then reverse. It starts in 2013, then it starts in 2012. I didn't remember, even though when you told the story, you said, I'll never forget. Like she's like, I'll never forget the first time. It was 2013. God is my witness. Then the next day come in and say, well, I made a mistake. It was actually 2012. When I told you it was 2013 yesterday, that was a mistake. And when I said an oath in the UK trial, it was also a mistake. It was really 2012. That's damning stuff, Bob. That's just damning stuff. And we're not gonna just talk about all the witnesses. So it's I think it's just at the point where, if it's gonna be about the facts and evidence, this is a 110%, no doubt about it, trial that is a he said, she said. Who you gonna believe?
Yeah. And it's like something is wrong with you, Amber. Something is wrong with you on some kind of level. I don't know exactly what the problem is. I'm no professional. I think maybe you lack empathy. That's a strong possibility. I don't know if you necessarily believe what you're saying, but I don't.
Nah, Kurt.
I don't think you have any dissonance or sense of dissonance from so either you believe what you're saying, or you have no sense of dissonance from disbelieving it. Either one is pretty scary, honestly.
I think she's trapped. I think she's trapped in it. I think it's got to the point where she's kind of trapped in this moment, and she can't get out, right? Because don't forget, think about the time all this stuff kind of went down. She just got Aquaman. She's hot, and they're like, they come to you, hey, why don't you write an op-ed in the New York Post? and we can pump it, and you'll be named you an ambassador for the ACLU, and it'll be great, and your career will be going off, and it'll be this is all the big stars do. She's looking at Aquaman and said, "I'll do it." Writes the op-ed. ACLU wants to push the op-ed under this guise of op-ed truth, but it's really they want to do a hit piece on Johnny Depp. I didn't know the ACLU was doing hit pieces on Johnny Depp, but somehow they got to do the hit piece against Johnny Depp. Everyone knew it was about Johnny Depp. They sent the thing out, promoted it as about Johnny Depp. So it wasn't even like a secret. And, she got a $7 million settlement for the guy. And the bad part about it, now, think about it this way. Johnny Depp paid her $7 million to divorce her and keep her mouth shut. And she did, and she literally didn't keep her. She literally spoke. So if I'm on a jury, I'm going to give him his $7 million back because she signed the NDA.
I'm giving him way more than that.
But that's the minimum. Like he gets his $7 million back.
I'm giving everything he wants. I'm giving him $50 million and more. I'm serious. I think he justified $40 million from just purely objective numbers. I think the from just pure economic losses is justified. I think reputational harm, forward-looking harm, is reasonable to calculate at $10 million and lost opportunities that aren't otherwise reflected in the numbers. It's reasonable it's just pure compensation.
Yeah, possible.
I mean, I think he's justified his $50 million ask.
Well, if she's justifying $40 million, then I think he's definitely justifying 50 because he was the biggest star. He's the biggest star, so he's going to make more money. Even she admits he's the biggest star. So, I just don't understand how you can go in there with a straight face and say is that he's going to make less money than her when all parties are great. He was the biggest star and he was making more money. So I don't know.
Yeah, that
was kind of weird. But we'll see because, at the end of the day, it's just regular people back there and try to evaluate, who's telling the truth, like, from all these different stories. But just from the outside looking in, I just don't see, there's so many people that I got to believe were just not telling the truth for some reason. If I'm going to believe one side of these stories now, I can line up some against Johnny, Amber's sister, and a couple other people say, but somebody brought it. There's only two people in this trial that says they ever saw Johnny hit anybody.
Mm-hmm.
And that's Amber and her sister. Every other person says nobody's ever seen Johnny hit anybody else, right? Everybody else in the trial. Is that convenient?
Yep.
What does that say, right?
Well, if I win this, if I'm Johnny Depp, I get $50 million. I'm selling off the debt to the 50 meanest debt collectors I can find, and let them all. I'll sell $1 million to each of them, and they can all go bother Amber to the end of time for their money, which is pretty hilarious. I feel like she deserves it at this point. Whatever empathy I might have for a person, I think has expired at this point. Because it's like, at this point, now it's bringing out whatever, I guess, sadism might be in me, because all I want to see is pain. Because she, deserves it.
Yeah, I like reading these articles, because they make this whole trial watching thing now like this alt-right thing. And when I read it, I'm like, it's funny because when you meet the Justice for Johnny Depp crowd, it's politically neutral. There's people from left wings, right wings. It doesn't matter. It's such a mixed group, but they want to just kind of put all those people who a lot of them are Democrats, those are their base, into this right wing group. And it's just funny to see because I have a lot of liberal friends who, when we talk about this case, the first thing they say is she's lying. They say she's lying. Yeah. They're not conservative at all.
Well, I guess I also understand a lot better the people that are in that Justice for Johnny crowd, because a lot of people knew a lot of this a long time ago and possibly is their source of some frustration with me and other people like Richard who have tried to keep themselves a little bit blinded to it. And so I guess I understand a little bit more some of the Justice for Johnny's crowd's reactions when I would say anything positive about Amber Heard, her testimony, her lawyers, or whatever, right? It's like I still stand by every comment I ever made. I still think it was an accurate assessment, at least for me. So I mean, I tried. I'm just trying to show you my hand, all right? I'm just trying to show you. Here's how I'm assessing the situation, and I'm coming into this pretty blind. It's like I didn't know, I didn't know about really anything. I heard little snippets, but really didn't follow it. And like I'm just showing you my cards. This is how I'm thinking about it, and but I understand them now a little better.
I honestly, if I had the same information that I had then when I made that prediction, I would still make it again. Everything that I knew about defamation cases, the burden of proof, all this stuff I knew about defamation cases, and I looked at John, I read Johnny Depp stuff. I said, okay, this looks like a loser. The statements just look too neutral. I'm a victim of domestic abuse. Like what? Defamation? He's not even named.
Yeah,
that's what I was thinking. And then I was kind of like, if it's a survivor motion to dismiss, he's lucky to get there. He survived it. And then I saw the evidence. And then I was like, well, now I understand why he survived the motion to dismiss. And now I understand why the Justice for Johnny people were like, you guys need to look at the evidence. But they also failed to realize that we like to go into this stuff kind of cold and kind of build our way up, because we're judging not only the evidence, but we're also trying to judge the performances. And if we already kind of made up our minds, it's like it's hard to judge the performances in that way, because we got all this outside information. Really, at this trial, you couldn't avoid it, but generally, that's what we do. When I was covering Chauvin and Arbery, it was just like, trying to stick to just what was going on in the courtroom. So sometimes we may be behind with stuff too, and people will send us stuff like, oh my God, but most of the time, we try to act like a juror or act like a neutral arbiter, just to see what we believe the outcome is going to be. So,
yeah. I mean, I think it's good to try to assess these things and try to assess them based on what's presented in court, because you never know. And a lot of stuff that is out there in the big wide world, like the Australia tape, isn't known to the jury. So, I mean, and also we didn't get anything like what some of the Justice for Johnny people were hoping we were going to get from the roommate.
Yeah, from Howell. Jennifer Howell. You heard almost nothing.
We got nothing of value from Howell. So that, I'm sure, was a point of frustration for everyone. So trying to remember what is and is not in evidence is important.
Oh, I do want to ask you something about Jennifer Howell. Why the hell did they call that witness if that's what they're going to get?
I don't know.
Like, I don't know. It was like a hostage thing. Like, she's all mad. Like, what the hell am I watching here?
I don't know what the point of calling Hal was. I don't get it.
They called us so dramatically too. We called Jennifer Howell to the stand. I'm like, oh my God.
Well, that was 20 minutes of disappointment. It's got all this tease up. Touch me in the morning and walk away, as they sometimes say. That's not fair.
I got everybody screaming the Declaration of Jennifer Howell. The
Declaration of Jennifer Howell. Shit, because it doesn't exist.
Not in the minds of the jury. We know what she said, but that's what we're talking about. We're all poisoned now with that declaration, right?
Yeah, absolutely.
Cast out here and say, "Oh, she's doing screaming on the screen." Jennifer Howell.
I see my good friend Good Logic is in the back. I'll just echo one thought. I was trying to look for the exact comment so I could put it on screen while I talked about it, about someone saying you can't be biased until you have evidence. I kind of reject this view of what bias is. I think bias is when you have an idea before you come in. A bias is you're skewed before you start. Like Lady Justice has a blindfold on, so she's not biased. But she also has scales. The scales don't make her biased, right, as she's weighing the evidence. So the fact that she comes to a conclusion doesn't make her biased. And I think this is an important distinction to remember, because I don't very much like being accused of bias, because I try very hard to not do that. I'm blind in assessing things fairly, or at least I hope I am. The fact at the end of the day that I wind up assessing something one way or another doesn't mean that I'm biased. Hopefully what it means is that I neutrally applied neutral rules in a neutral way to whatever the decidedly non-neutral facts turn out to be. and then reach a neutral assessment based on those facts. So I reject the premise that reaching conclusions is necessarily indicative of bias. With that being said, let's bring on good logic to the stream.
The
How
most
is it,
biased
brother?
member of Law 2.
Ah.
I actually came on just for a minute because I'm actually heading over to my own stream soon. So my regular scheduled program at 10 p.m. But I wanted to mention to you that I think I have the answer on the whole Jennifer Howell confusion thing issue and why that came in.
Okay.
So here's my theory. Okay. They expected to have a much lengthier version of Jennifer Howell. You might remember they ended a half hour early yesterday. And I think that was an accident, or that was a change. And they ended up eating that time that they ended in a half hour early. And I think they lost a half hour testimony. And what happened was that they expected that they were going to get a fuller deposition testimony from Jennifer Howell, which would spell out how, Whitney came and she was crying about how she had to stop Amber from killing Johnny, and that this was going to be the perfect, and they were going to argue that this is obviously it's hearsay, but it's an exception based on prior inconsistent statements. But when they got up there in the morning, they said, and when the team Amber saw what they're planning on putting up there, they said, this is not a prior inconsistent statement. There's no time that Whitney, when she was on the stand, said anything about what she had told Jennifer Howell. And this only underscores the level of complete and total screw up in the cross-examination of Whitney Heard. That, fine, you got in there that she's a friend of yours, but you had to go further and say, did you ever talk to Jennifer Howell about this, about you're leaving the ECB and moving in there, and what happened in that conversation, and let her tell her version. And that legally is the only way you're able to get in a prior inconsistent statement. If you don't flesh it out from Whitney, it's not a prior inconsistent statement. So you can't, so you can't get it. You cannot get it in there. Now, and what happened was, I think that they were forced in the morning. There was a lengthy thing yesterday, not this morning, yesterday morning. There was a lengthy sidebar before court started, which it seemed as if Team Amber won. Now, if you're sitting there as Team Johnny and you're told, okay, you got to shave out now a half hour of your testimony, I think they said, okay, well, look, we're going to shave out that part. We'll put the rest in. And they didn't realize how stupid the rest of it was. That it's like you sort of they didn't have a time to reassess and say, well, what the hell we even bother putting this up here? Because it's like this whole, a 2/3 of an eaten appetizer and the entree is never coming up. We're not going to see the entree. There's no entree at all. We just threw the entree in the garbage because the judge didn't let us bring it in. And now basically we have this little appetizer with her talking about how Whitney moved in with her, and like, okay, what does that do anything? I think they didn't have time to assess how that testimony would play absent the entree part of, and here's what Whitney told me about the fight on the staircase between Johnny and Amber. So that's what I think is what happened. They basically stuck to their original game plan of putting that deposition up there. They had to lose a half hour of it. That's why they ended up cutting short a half hour in time, and they didn't have time to really assess how that deposition would play without it. That's my read about what happened with that deposition testimony. But I certainly would appreciate, now that I've laid that out, what do you guys think about my theory?
I mean, it sounds reasonable. I'm not sure whether I neither agree nor disagree with it. I think in the end, it just didn't really go anywhere. I think your idea makes sense. Yeah, I don't really have a strong opinion on it one way or another. Nate, the lawyer, do you have an opinion on that?
No, I just got back. I'm an opinion on what? Sorry.
What Joe was just saying. It doesn't matter. He was just laying out why he thought
I was
the
rambling.
Howell stuff was good. Yeah, he wanted to ramble, which is fine. I do appreciate when there's an opportunity to explain thoughts in more detail. And so
I was explaining the litigation strategy, and that basically yesterday morning before they aired the Howell testimony, the judge said it's not a prior inconsistent statement. You have to cut out that whole conversation that you had with Whitney, and that's why they
fucked it up. They fucked it up on the cross of Whitney.
Yeah,
they absolutely did.
How'd they fuck it up?
Because they failed to present Whitney with the prior inconsistent statement, which they have to do under the rule.
Oh yeah.
That was
yeah.
a total fuck up. And once, what's her name? I always forget her name. I want to say Amanda, but I know that's not right.
Oh, she's terrible.
No, it's one of our people.
I know she's terrible. You're talking about the blonde chick in the back, right? The one who cross-examined Whitney.
No, I'm talking about Law 2 people.
Oh, you're talking about Elite. I'm just kidding. Totally joke. No hate.
The one with the art on the wall, the like fishes and stuff on the wall.
DUI guy?
No, it's like metallic and stuff. Andrea, thank you. Andrea, thank you.
Andrea Burkhardt. Right.
Yeah, Andrea. I wanted to say Amanda.
She's great.
Andrea.
Great.
Yeah, no, I was like, it's one of our people. No, once Andrea pointed that out, I felt like such a complete idiot because it was so obvious. And it's one of those times when someone says something and you can't believe you missed it. It's like so obvious.
Mm-hmm.
And it's one of those times you're like, oh, how did I miss it?
So hold on, what did she point out?
So she pointed out this fact, which I totally missed in the analysis. In order to use it as impeachment, you have to present it to the witness first. And they didn't do that.
Yes. They did. Oh, they didn't read the statement to you, like they did today with Johnny. They said, "Did you say blah 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 blah?" He said, "No." Then you can impeach.
And they never presented the statement to her. They never showed her the tape or the deposition or anything. Like they never presented Whitney with the contradictory statement. So that was a total fuck up on cross by Team Johnny Depp because they failed to do that procedural step, they can't impeach with it. And once Andrea pointed that out, I was like, oh yeah, you're totally right. They fucked it up, didn't they? Because I had missed it. So it was nice to
but how do you impeach? All right. So when Whitney's testifying on cross, you're going to ask Whitney.
Yep.
Did you once tell Jennifer Howell blah? Or did you once say blah 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 blah?
You could show her. You could
show her the letter.
Show her the declaration. Tell her to review it and ask her if she disagrees with anything that's written in there.
All right, that makes sense. Because the deposition itself can't come in because it's hearsay. It's done. Mm-hmm. It's hearsay within hearsay, right? What she told me, so that's it. That's done. So you can use it as a demonstrative for her to show. All right, yeah. If anything, and then get in through that. All right, that makes sense.
Right. So that's why I think they ended a half hour early, and that's why they ended up presenting something which, when they first planned on putting it up there, they figured it was going to be this delicious gotcha on Whitney, but once it got shredded to pieces, it was
so why call it then?
I think they just forgot. I think sometimes you're in the heat of you're in the heat of it. They got this. I think they lost that motion that morning. Like they were told, you can't do it that morning. So they're adjusting on the fly.
Look, we gotta call Jennifer Howell watch her scream, and the whole thing make no sense.
Yeah, it made nothing. It was just baffling. It was confusion.
Twitter's like Jennifer Howell, like everybody's screaming the name. Jennifer Howell has got the magic touch.
Yeah. I was tweeting out, "Here comes Jennifer Howell. This is gonna be delicious." And then it's like, 10 minutes of confusing conversation, and we're done. Okay. Like, wait.
We hyped everybody up for Jennifer Howell.
That was embarrassing.
Jennifer Howell was a letdown. Yeah.
But anyway, I gotta finish making my intro. So, good seeing you guys.
Yeah.
Take care, Joe.
Yeah. So that's it's an interesting. So I think everyone who is hoping for justice for Johnny, it's like I totally get it, and I think trying to find a win for Amber Heard out of all this, man, it's like, man, it's so, I understand. It's like there is.
Well, we can go over the scorecard right now.
If
we're talking about the court of public opinion, I'll say this. If it comes to pro Amber Heard, I think that is not where everyone's at. I think more people are pro Johnny Depp. But I think Johnny Depp has had better PR, and his lawyers have been doing a better job at managing PR. Let's just call it what it is, right? Every time Amber says something that's wrong, how many times in this trial have we heard about the umbrella guy, right? So the umbrella guy is been they were sending the information out. Except I think I sometimes you can recognize the game without hating on the game. And I do recognize Johnny's game. His game was let me hit everybody with the hardcore facts via social instead of going through the mainstream. Because if I go to the mainstream, then you're gonna have some anchor who gonna filter it. Oh, look at Johnny Depp trying to put something out that makes some sense. And here's the tape, right? And that filter, the CNN filter, that filter is going to try to promote a narrative. But by dumping it to people like the umbrella guy and all the people just on social, and raw file footage, then it's kind of like it says what it says, right? She said what she said. There's no denying that evidence. And I think that's how the game changed a little bit, because now the upswell of people who are watching the trial and just kind of seeing it are presented with everything, right? There's nothing, whatever that jury's seeing, everybody in the world is seeing every day. And we're all coming to the same conclusion. Now, could 12 people in that jury pool be that divergent from the general population? Maybe. But I'm just saying, from what I'm seeing, and maybe I might be a victim of my own bubble. But people from the left, I had a friend the other day tell me, yo, Nate, I'm extremely left wing. But I think just he's straight up lying.
Mm-hmm. Yeah.
So, hey, I just think the tactics used in this trial to get the information out was interesting. And I think it's also an indictment on the mainstream media, because that was Amber's vehicle of getting information out.
Yeah.
Her vehicle was the mainstream media. Look at her. She's calling up TMZ. I'm going to be here. I'm going to be here. She had all that manipulated.
Yep. She is manipulative, lying, over exaggerating, horror show of a human being. It's amazing that she was as successful as she was. Maybe if fate is kind, she'll wind up on Skid Row or something. That'd be good.
Yeah, listen. I think she's gonna be okay. Johnny's gonna be okay. The one thing I do like about this trial is, somebody said the other day, Me Too men also, right? And in terms of, I think that's the thing, because we've been saying it all the time, right? If the genders were switched in this thing, we wouldn't even be talking about this case in a serious manner, right? Just imagine a husband. You hear a tape where the husband tells the wife, "I hit you, I didn't punch you." She's like, "I know what it means to be punched." He's like, "Shut up!
Tell the world.
Right? Tell the world.
Judge. Tell the jury. Yeah,
tell them I hit."
Yeah, and
what? Really?
And, fast forward. I hereby sentence you to 15 years. Is basically the next thing you expect to be happening about that point.
Just imagine. You walk in. She's got a black eye. He's like, "Oh yes, it was an accident. It was an accident."
She cut off her own finger.
Yeah.
Mm-hmm.
That bruise, that was photoshopped in. That picture of him being punched.
Nate, I'm going to jail, aren't I?
Why?
I'm just saying, in this hypothetical where the police are at my door, I'm going to jail, aren't I? I don't want to go to jail. I didn't do anything wrong.
I'm telling you, man. It just, our story's incredible. But I think
very literally incredible.
But I think at the end of the day, it forces us to evaluate how far the pendulum has swung. And right now, instead of being, just believe everyone based on their gender, it's believe accusations, follow up to look into evidence, and then see where it goes, right? I believe what you're telling me is true when you tell it to me, but the evidence has to back it up. It's trust but verify at that particular point in time, right? I'm going to take all accusations seriously, but that doesn't mean I'm going to make an arrest just based on accusations. You need other things to build that case. So,
yeah, for sure. For sure. The whole thing is just Very, very disappointing on a whole number of levels. People suck.
Yeah. So what do you? All right. So going into the next tomorrow,
Hmm.
defense got 1 hour. Number two things that we don't really. I think sometimes we have to be fair to the defense. They have, I think, gone from maybe a 4-3-4 in their practice style to maybe like a 6-7, possibly even a hard 8 in the past couple of days. And I just will say this, the cream rises to the top and pressure busts pipes and blows up volcanoes. And they're working well under pressure with the time clock issues and all that stuff. They've been making commando raids, getting in, just making things a little muddy and getting out. They don't have a lot of time, but with the time, the way they are using their time, I think has been effective. And, sometimes it's not about how good your case is, but how well you can prosecute that case. And I think the past couple of days, we have to give them some credit for making this a fight again, because it was a runaway, right? This was a run. This was Secretariat. He's up by 26 lengths. They now at least threw some mud in the game and made it a fight again. What do you think about that, Kurt?
I guess. I'm just, yeah.
You don't think they're
Okay.
doing a better job?
I think they're doing a better job from not having enough time. I think that they were bad at time management. I think that's a problem.
No, I'm talking about for the past 2 days, the cross examinations. They've been
Yeah,
better.
I think
than
they're doing
before,
better
right?
because they're. I think yeah, they're doing better because they don't have time. They're doing better.
Just imagine if they ran their case like this from the start.
Yeah,
They'd be in such a better position.
yeah. Why is Kurt so sad? Some people keep asking. I'm sad because I was talking about things that were depressing me. When I go to emotional places, I tend to show my emotions. So I'm sad because I was talking about things that were depressing because of bad horror show things. So yeah, I was talking about when I go to I tend to show my emotions on my face when I'm feeling emotions. Which for all those of you who say like I'd make a bad poker player, I'm very analytical, as you know. So I'm pretty good most of the time handling my emotions. So actually, I'm a pretty good poker player because most of the time I don't do that, as you guys see from most of the streams. Anyways, I do have some super chats. Sing us a song, cheer up. That's a good point. What song should we sing?
I don't know.
We are the world. We are the children. Let's lock Amber Heard up so she won't hurt us anymore.
Oh, man.
There are evil people in the world ruining our day. Make the world a better place by getting rid of turds.
You know what, Kurt. So I want to ask you, since we've seen the trial is essentially over, right? There's nothing that's really going to razzle dazzle us the next day and a half, more than likely. So George probably more or less baked in. How would you vote on the 3 counts?
Are they actually
First
going to break
count.
it up separately?
Yeah, the 3 counts. Yeah, it's each 3 because there's 3 statements. First statement about the sexual violence.
Yeah, that's defamation for days.
Defamation.
Defamation for days.
Victim of domestic abuse.
It's a tougher one.
There's 2 of those. So really, if you're saying good for the one,
The third
good for the
statement
second
doesn't
one.
do anything for me. So I would probably not find defamation on the third statement. I've definitely find defamation on the first statement. The second one is a little bit more tricky because I'm trying to but it's
Did Johnny Depp commit domestic abuse? That's going to be the question.
Well, it said 2 years ago because it's bringing
Yeah.
back into play, as Amber Heard herself brought in. It's bringing back into play the exact thing that was happening 2 years ago, which by her own admission, I'll get to super chats eventually, Dylan. I'm working on it. I'm having this discussion with my guest. As she mentioned by her own testimony, she was talking about exactly Johnny Depp. Because she was asked, "What did you do 2 years ago?" And she gave basically the worst possible answer. Well, 2 years ago, I was filing my domestic restraining order against Johnny Depp for the abuse. I'm like, oh, okay, all right, that's pretty specific. So now you're bringing into everyone's attention that specific thing. So, and that was false. So I would find that statement to be defamatory as well. So the first one defamatory, second one defamatory, the third one no, not defamatory.
Yeah, I think the first one he's got. Second and third one, I'm 50-50 on, because if you get a mad Joy running through, liable for everything, burn it at the stake.
I think the third one's tougher.
I can see a Joy getting it, but I honestly think I think your assessment may be better, maybe more correct. But I think the title gets.
I mean, if the vote, if I'm in that jury room and there's 6 votes for finding liability on that third statement, I am definitely not caring enough to make a nuanced point about the issue. Like, I am not caring. So if there's 6 votes for let's find them liable for that third one, I'm like, yeah, you got vote number 7. I'm not, going out of my way to vote against this because of some hyper technical perception of mine. It's like, I don't care enough to make this swing for you. I'm not going to go to bat for you on this one. So, it's like, yeah. So, yeah.
Really good. Be glad you're not in the jury.
Man, I'm telling you, man, you really want me to go to bat for this? Geez, hey, members of the jury, I know, we only need to get 51%. But on this third statement, man, let me tell you why we don't have it. And let me really go to bat for Amber Heard. It's like, I don't think so, Tim.
So how bad do you think the stuff today hurt him then?
I don't think
how bad
much.
do you think it hurt Depp?
I mean, no. I think Johnny Depp was a weakness for himself. I think he hurt his own case a little bit. I think it would be wrong for me to deny it. I thought that TMZ guy was good. I thought Dr. Curry was great. Did wonderful jobs. Johnny Depp at least did get some stuff out that was bad against Whitney and sort of undermining her credibility. So that part was good. So that was helpful. And then the last guy for the day, who was okay. So, I mean, on the balance of the day, I think it's still a net win for Johnny Depp. I think he didn't do himself any favors in the jury's eyes, but at this point, I don't think they can be bothered to care. At this point, I can't be bothered to care. Johnny Depp has so many points in his favor. It's like, okay. It's like, okay, I'll call back that play. All right, I guess you didn't get that touchdown after all. You're still winning 70-3 instead of 77-3. So sad, I'm like, okay.
So there's probable cause to believe the statement. Not probable cause. There's by preponderance of the evidence, you believe the statement is false. Yeah, I think the first statement is just clearly under that
total
standard.
False. Sexual violence, bullshit.
Yeah, I think
bull to the shit. Sexual violence.
The abuse ones.
I will die on a hill.
Those are the ones I'm a little tired
I will die on a hill for defamation for that first statement at this point.
Now watch.
If it's 6 votes,
come back up the other way.
If it's 6 votes the other way, we are staying in that jury room.
I will
fight you on that one. We are staying here. I'm going to fight you on that hill. There is no way.
I'm telling you what's going to happen. This George going to come back, and the third one and the second one they're going to find them liable for, and they're going to say the
not the first
violence
one.
Yeah, they're going to reverse it on us. We're going to be like, oh my God, really? Kim Potter. This could be another Kim Potter.
So stupid. I still think Kim Potter should appeal, and I think she can win. Does she appeal? I don't even know.
I don't know if she's appealing. That's a great appeal. That's a winnable appeal. I
think it's a winnable appeal. The judge wrote my appeal for me in her own statement. So the Kim Potter, the judge wrote my own appeal for me in the sentencing. I mean,
on the record, yeah. I just didn't know what she was doing. What? She
used the word mistake quite a lot of times in the sentencing. Quite a few times the judge mentioned the word mistake. Couldn't help noticing, didn't mention the word manslaughter very much.
No. And only going to give it 18 months.
Wasn't she sentenced to like nothing?
Yeah.
So it was all suspended?
No, I think it's like 18 months, something like that.
Oh, wait. Yeah, she was sentenced to some time. That's right. Or was it all suspended? I can't remember anymore. No, doesn't matter. Doesn't matter. Yeah, I'm not gonna die on the hill for the third one. If the jury wants to find liability for the third one, I'm fine. If the jury does not want to find liability for the first one, we are staying here. No one's going home ever.
Well, so what you got? What you got next? You gonna start reading some super chats?
I gotta read some super chats for the people who've been donating for this time. Yes, let's read some super chats. Okay, Jeremy said the guy from TMZ was hilarious. He was funny.
He was good.
It was a good moment. Merck said, been waiting for hours to do this. Chemistry you bring to the group is sublime. Cheers. Thank you very much. Hobie said, hi. MCM Movi came over from Legal Bites. Thank you for coming over.
Hey.
Please remember to subscribe if you haven't done so already. We are trying to hit that 100,000 mark. It would be really, really appreciated.
100K.
I want that silver button pretty bad. I want it as validation. I want it as validation of what I'm doing at this point. I'm not beyond admitting to the need to have some validation in my life here. Kiki says, what's going on with James? He got blacklisted. No comment. Ashley Westby, keep at it. Road to 100K. You deserve all that's good that come to you. Thank you very much. On a smoke break, you give an excellent recap and insight. Love it. Thank you very much. Rex Racer became a new member. Thank you. Stephanie H, good evening. Enjoy listening. Thank you very much. TMD, psychiatric resident physician here. Medical school is hard, I would imagine. Yeah, everything I hear about medicine and medical school makes me very glad it was never an interest of mine. Psychiatry is a bit of an interest of mine, but like, how do you guys do all that? I don't understand.
My undergrad degree is in psychology.
Yeah. Do you think Dr. Spiegel now has ruined the credibility of the field? No, I don't think that's true.
No, he's a hired gun.
You always have Dr. Curry to bring reputation back to the field. So just put Dr. Curry on all the posters. You guys will be fine.
And he's definitely a hired gun. He's whatever you want him to say, he'll go up there and say it.
Yeah, absolutely. Just making sure I check these super chats as they come in because I have to
for experts. They call it for experts. It's a nice little gig they got. Absolutely. Because as long as you say the right things and you're taking a lot of money, then these experts are getting, what is it? Really about hundreds of thousands of dollars, right? Because this guy's getting $5,000 every day sitting in court. He's getting $1,000 an hour for the deposition. He's giving hours in the deposition, hours in this, hours in this, hours in testimony, right? Research, development, reports, all that stuff. Dr. Curry didn't say, she said $300,000 was a little high, but she didn't say it was out of the, it was like, not a number that could be possible.
Indie Girl gave $1.99 as a super sticker. Thank you very much. Anita, if the Molly text is from JD's phone, it was an incoming call. I don't know that we can draw those conclusions.
We just don't know yet.
Even if we could, it wasn't brought to the jury's attention. So Johnny Depp kind of mentioned it, but you need some experts there on that. Morgan Spencer,
like that's not me. That's out. That's incoming. That's not outgoing.
Morgan Spencer, Kurt, you give me Philip Seymour Hoffman vibes in all the best way. I've definitely heard that before, but I appreciate it as a compliment because I think Philip Seymour Hoffman was pretty good looking. You'll be happy to know that with me, not so much with the heroin. So that's a plus. DK Me, nasty unrecognized text says incoming. Hope Depp's teams revisit strains out. Maybe. Joseph says, can jurors study case law in their free time? I guess strictly speaking, if it has nothing to do with the case, kind of, but no, not really.
I say stay away from it. Stay away from it. If you're on a jury, stay away from any case law.
Yeah. That one chick, $10. Hey, Kurt and Nate. Found you guys through Makita stream. Thank you guys for all you do. I really do appreciate that.
Thank you.
John Granville, $20 from Canada. I know this is not a popular opinion, but I've been convinced at least some of the abuse Amber Heard reported is real. Probably some of it is real in some sense, yes. JD hasn't done a good job of disproving that for me personally. I'd be voting for neither to get any money. I think you're wrong because I don't think you can prove sexual violence. I think it's a total non-starter, and that's enough for Johnny Depp to win. I really think the evidence doesn't really exist for that proposition. Carolyn, $1.99. The jury doesn't see TikTok. That's all mute. Damn straight.
That's true.
Jimmy the Rabbit, $10. Cross said he told his story already. He was rebutting that he couldn't tell a story in the UK. His 4 days on the stand in the UK with some lawyer attacking him not telling a story. Yeah, I mean, he was trying to do that. I just didn't feel it was particularly effective, but just my opinion. James Carson, Kurt, take the lead on a case in your case and have a panel. You deserve it. You're teaching us a lot. Well, it is my intention. It is my intention to cover the Marilyn Manson case if it is streamed, and it is my intention to cover the Daybell stream case if that's streamed. So hopefully some of my LawTube friends will join me for that, and we'll see how that goes. That would be awesome. Thank you very much. Brian Larson, Depp could have been put on the stand to drain Amber Heard's time.
Good point. Good point.
Angie Stewart, thank you, Kurt and Nate, and all the law tubers for sharing your knowledge and time. What a journey it's been. What's the next trial law tube will be following? Manson, Daybell. Betty Dance, if they didn't put it on the stand, then tomorrow Amber side would have called him. I don't know if that's true. But thank you. Lone Star Law, male victim of DA from a BPD female here. We shouldn't have to be perfect. Why aren't we allowed to react? Double standards, JD's cross shouldn't be the end. I agree male victims are treated like shit, and I really hope at the end of this, Johnny Depp will do some PSAs for male victims and male resources and making it okay for men to talk about it, because that would be really good. That is my one true hope in the world. I hope Johnny Depp does some PSAs and stuff for some male domestic violence and brings people's attention that it's not okay to sexually harass men. It's not okay to just randomly grope men. It's not okay to randomly slap men. It's not okay to punch them. It's not okay to all the rest of it. So I really hope they will do that. I bring this to everyone's attention because I was watching a video at one recently where a woman was at Disney World and Gaston was there, and it's just a guy, and the woman just has absolutely no problem just putting her hands right on top of his chest, like his boobs basically, and he just says, "We're done, go away." And she doesn't understand. She doesn't understand why she's being put away. And I'm like, it's not okay. It's not okay to run. And I've heard from Disney people that they get worse than that. They get groped and all the rest of it by women. And yeah, it needs to stop. Murray Sutherland said, your gift to legal advice today was awesome. She deserves it. Mrs. Quaggs, when will you know what the seven juries are? Probably the moment. Well, I guess strictly speaking, I guess we'll only know in so much as when they're selected, which will be at the very, very end. Melissa, and I'm not sure what happens to the alternates if they go home or they keep them in reserve somewhere. I'd keep them in reserve somewhere, but I'm not sure what the law allows for. Melissa says, short and sweet summaries here, Kurt. Thank you. Mark says, I trust TMZ over mainstream media. Fair. They may be salacious, frivolous, but they show original footage of original sources, so their accuracy's up there with LawTube. Okay. $2 from Kathy Betsy. Will you be covering the Daybell trial? That is my current working plan. Patty B1211 said she worked for the airport, not a police officer. It's ambiguous what her role at the airport was. At least to us, it is. Faye Gwen said, became a new member. Thank you. Mostly dead. Nate, what's the Laracle prediction? What is the Laracle prediction?
Sexual assault. He wins. I think he may lose on the other two.
And Amber Heard's just done?
Oh yeah, hers is done. I don't think she gets paid.
Sergeant Snafu Bokia, I gave up on feelings. If the Army wanted me to have them after the service, they'd given them to me. Funny, I get it. I got a plaque and a flag, no feeling. Well, the Army may not have given you feelings, but I'm here to empower you. I will give you feelings. Amy Small, though no precedent is being set, I worry if they let Amber get away with this. We'll end up with men being worried about being ambered in the future. No doubt. Bailey gives $9.99. Thank you very much. Jonathan said, satanic laugh has struck with me, pure evil. Yeah. The Law Patrol. Is anyone else having issues with the super chat? I legitimately can't use the L or S words, the YouTube things. Again, error message when I try on the channel, all their messages go through. Yeah, so super chats are restricted differently than normal messages. And I don't know what those restrictions are, but I know from having fought with YouTube myself, I mean, in terms of trying to say things. So yeah, there are things you can't say in super chats that you could say in the normal comment. So that's just normal. So you have to work around it, and you have to figure out what the forbidden words are and then figure out the solutions. But yeah, they don't like the word subscribe particular. You have to figure out alternates. Lena Nami Star. I know TMZ guy quickly giving a glance twice at Amber Heard's team when he's asking about source by JD's team. Wonder if anybody noticed. Yeah. I think everyone was able to deduce what was going on. Vez from Quebec. It's impossible for you to connect the emotional wreck she was going for in her testimony and that creepy, satisfied smirk. Yeah. Beck's fire. Kurt's right. AH lacks empathy as she's a narcissist. HG Tudor has done an excellent series to substantiate this. Thank you. Melissa Maciferin, thank you for opining. Surfergram, I used to donate to the ACLU. After the overt shady involvement in this case, how do you think this will impact the ACLU? I don't think it will impact them very much. I think they've become increasingly polarized, and I think the people that love them will continue to love them. I used to donate to the ACLU because they used to be a reputable organization. But, not so much. Courtney, she should get out of this mess by fessing up, taking on the chin, and apologizing. 70 mil for Johnny sounds nice. Loved you both, Kurt and Nate. Thank you very much. Flutterby says, don't feel bad about your views before. I don't feel bad about them. I just, I'm just open with them. I stand by every word I said when I said it. Those were, in fact, my views at the time. So it's like, I don't feel bad about it. I can only talk about what I know at the time, right? I mean, obviously. Ashley says, hurt people. It's okay, Kurt. Thank you. Harley says, I'm not super right-wing. I'm super not right-wing and pro-Depp on this one. I don't think it's political at all. An AB survivor, we know a bullshitter when we see one. I don't think the support for this has been political. The underlying issues with Me Too, of course, are more political. But and we've seen a lot of articles from the media trying to make it political. So, but I tend to agree with you that in reality, it's not political. Deadline is reporting Amber Heard to take the stand again. Take that as you will. Not sure how that'll help her. With what time?
An hour left, though.
She's got an hour 15. I can't imagine any good is going to come from this. If I'm her lawyers, I'm just telling her no. Ian Kensley.
Hold on. That's the best possible scenario. You have 15 hours to cross-examine her or whatever. They got like 10 hours left, right? Or something like that. No, they got 7 hours.
Just cross-examine her forever?
No, I'm saying, but you put it back on. You leaving them with that much time? Like they don't have to take their time. Like how this side has to take their time. They got to do it strategically, get in and get out.
Mm-hmm.
They don't have to do that.
Mm-hmm. Fair. Ian says, Howell's Depot allows JD's team to say in closing statement, you heard Whitney's dear friend express concern about Whitney lying to protect Amber. It's a weak statement, but sure. Swell guy, why did Johnny do so poorly? Much work to ruin it. Couldn't speak to that issue. Maybe it's lack of prep or something. I don't know.
I think it might have been a little arrogance.
Maybe a
little by the legal team too, to understand at this point in the game, we try to limit just unforced errors, right? If we don't have to put the client on, putting them on is definitely a no. Unless you're positive you can get a plus out of putting him back up there. If you can't get a positive from putting him back up there, you don't put him back up there. There's no need to. So
Mrs. Quag says, I hope the end of the Depp close with Amber's hyena taunt and go tell the world, Johnny. I think you're definitely on the right track on that one.
That's the end. That's the close. Track. Go tell the world. Well, he did. Now, what's the world going to do to him?
Yeah. Ian Dunlop. Doesn't Jennifer Howell's letters and other items in her deposition get admitted? It does not appear so. No. Layan says, came in here late. Did you guys have an opinion about those texts that Johnny didn't recognize, which might not have been from him, since they said they're incoming rather than outgoing or from Johnny's phone? No, I didn't have any particular opinion about that one way or another. I didn't feel that point, to the extent it existed, was very well developed. So I mean, it didn't really do anything for me. I mean, everyone chat noting it. I was like, I'm great, but I didn't really get enough from the chat. I apologize from the jury. Apologize. Let's try it one more time. From the day for it to affect my judgment one way or another. The Law Patrol says your inner Amber is showing. Is it? I hope that's not true. That's very sad for me. I guess we're all flawed inside somewhere. Angry Roach, is the judge going to tell the jury about AH not turning over evidence? Only to the extent it's in the jury instructions, and we'll see about that very soon. Debs June became a member. Thank you very much. Spooky Ghost, DUI guy just said on stream, jury's not allowed to have notes during deliberation. During deliberation, I'm almost positive they are. I could be wrong, but I'm almost positive they do. Betty Boop, I disagree, Joe. You guys are lowering it up too much. Jen Howell was able to accept the idea that Whitney was lying and should do the right thing. Yeah, but it's just one person's statement. It's a statement from nothing.
Yeah. Whitney, just don't lie and do the right thing. We don't know what she's talking about. It's just totally out of context. It's just like a totally blah.
Gerardo says texts were not from Johnny Depp. If you look at them, there's a direction. Yeah, I mean, again, that point was not very well developed at the trial, in my opinion. So at this point, I don't really think it matters. But thank you for your observation. I mean, again, you have to remember what the jury does and does not know. Sure, they can see those things, but the point wasn't well developed. Also, there's 6 weeks of trial. So, does the jury notice that? Do they not notice it? So, yeah. Militia says, Court TV says Amber Heard takes the stand. I can't imagine what good comes from that, but okay. Arnett says, just want to say, keep it going, guys. Cheers. Thank you. Casey says, what about the jury, Nate? They don't see that. That's one of the reasons we try to remember what is and is not being presented. Wiley Bird says, WH didn't finish her deposition, so they had to rebut. Okay. Tasha says, I really appreciate your objective reviews. Listening to you and others taught me so much and sparked my interest about how the law is put in practice. Excellent. Beverly became a member, or donated $1, I should say. Crazy Meat Cat Queen, men too. Absolutely. Mostly Dead, $5. The texts were from 2017. I suspect they weren't about a woman. I think he wrote them, but then he forgot what context. She certainly has lied more than him. Yeah.
Yeah, but if we're talking about lied more than him, then that's not what I want the jury to be thinking about my client. I want that he's not lying at all. He's mistaken. People can become mistaken, but he they asked. He even doubled down on. No, it is. I've never said anything like that. And this guy something about let's go to the text messages. Yeah. If he didn't double down, I think it would have been just like a regular hit. But him doubling down, saying I wouldn't accept, you're crazy. But it would make sense if they were incoming and not outgoing. That would make sense. Then his story would make sense. And I think if they could get that in somehow clear tomorrow, then I think that's a banger. But I don't know how they would do that without having to put Depp back on again.
Absolutely. Shempasa says, how much more complicated would this have been if there was someone transgender identified as not a man or woman? I mean, endlessly, one would imagine. Pinky Pink, what is a lefty? You're funny and good, man. Thank you. Appreciate it. Crazy Cat Queen, 3.6 thousand on, 1.7 thousand likes. Smash those likes and subscribe. Thank you. Slum John said, rebuttal for AH tomorrow. Who are they bringing in? I have no idea. I guess we're going to find out when it happens.
Yeah, Court TV is saying Amber Heard, baby.
Susie became a member. Thank you.
Susie.
Dean, $20 from Australia. May have been covered. Your thoughts on the Court of Appeal? There are no appealable issues that I see at this time. Mega.
I think there are a couple. I hate to say it, but I'm appealing fast because I don't think these statements qualify for defamation. I understand that, but we're gonna have a hard talk about whether these statements can even be proven to be true or false. And whether a reasonable jury could do it. Not saying that they're going to be successful, but I think there's still a lot of fertile ground for an appeal, especially with these statements, because these statements are pretty vague. I do understand the overall point, but not appealing it would be disastrous. I think that would be almost not being looking out for the best interest of your client, because these are definitely appealable.
Fair, that's a fair point. Mega Carpal Tunnel says, theory, teams AH is doing better now because with time so low, they don't have anyone talking. I think it's art from adversity is what's going on. Elizabeth said, one makes video on another's phone. Who owns the copyright? The person who made the video.
Yeah.
It's always the person who in the words of the copyright law, it's the person who fixes the work to a tangible medium. So it would be the videographer would be the copyright owner. Zykes, $2. I appreciate you. That is all. Thank you.
And
AC
how right
says,
and how right were we with that with our TMZ analysis the other day? Because that's exactly what we said. TMZ, to own that copyright, had to get it from the original copyright owner, which is the person who actually made the thing. So how did they get it from Amber Heard? Either she got it from her directly, or she transferred it to somebody who transferred it to them. But that paperwork would have had to be done too. So there had to be something. And now we know if they get the copyright from the source, it's generally about 15 minutes. If they got to go through an in-between, that usually takes a couple of days. And they got this one in 15 minutes.
Casey said, Kurt, honestly, did today hurt JD? I mean, JD lost some points, but I think it was an overall win for the day for Johnny Depp.
Yeah.
I bet he lost some points, and it's worthy of notating. Susan gave a super sticker, $27.99 from Canada. Thank you very much.
Ooh, nice.
Andrea said, Umbrella Guy tweeted, I got a linger inside of me. Quote, Rodenbaum asked JD about, and what she couldn't remember is actually from a 1995 tabloid called Premiere. I would, with all possible respect, think that I've got a lot of anger inside of me may not necessarily be a quotation or a reference to anything in particular. It sounds like just something a person would say. So I'm not sure it was necessarily indicative of anything, but okay. Softgrim says, I hope Depp wins and is given $1 and Heard is forced to pay the General Hospital. She can't be ordered to do that. That's not on the table of this trial. All that can be done is having her pay money to Depp. That's it. Walter says, love your channel. Thank you. Rex Racer says, I love Depp at moments today. Ron Bourne, and you'll be okay. We're amazing. That was not necessary. Yeah, with like the Ron Bourne stuff, it was not charming. Just a massive day for snark in the courtroom. There was definitely that. Lindsay says, Yas here for the LVD coverage. Cannot wait. Been following that case since the kids went missing. Here's hoping for justice. The case is so complicated to me, I'm not even sure what justice necessarily looks like at this point. I'm looking forward to finding out at least a little bit because it's so strange. I don't even know what's going on. It's like,
Kurt, let me get on out of here because I got some stuff I have to take care of. But if anything, I will see you on the next one, brother.
Yep. Thank you very much.
Not a problem, bro. Take care.
All right. Appreciate it. Sit up. Looks bad when I'm just the only one here. Sack of documents said, random question. If a visual was entered into evidence, could they say a fact wasn't proven? May Dr. Photo. Yeah. I mean, the jury can believe what are facts and not. Like a photograph being in doesn't make something a fact. The jury is literally the finder of fact. It's only a fact if the juror says it's a fact. Period. End of discussion. Fingerprints aren't facts. DNA isn't facts. Videos aren't facts. Photographs aren't facts. Documents aren't facts. Testimony isn't facts. Nothing is facts until the jury says it's a fact, because that's what the jury does with their time. They are the fact finder. So they can absolutely look at a piece of evidence and say, I don't believe this for any number of reasons. I don't believe this photograph. It is not an authentic photograph. It's been manipulated. It doesn't accurately capture the scene. There's other things going on. Whatever. It's not well lit. It's too dark. The person taking it is biased and blah, 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 blah. Right? So it's up to the jury. What does the jury find as to be facts? That's literally what they do. So can a jury look at a photograph and say, this is shit? Yep. They can absolutely do that. This is a shit photo. This photo sucks. They can absolutely do that. That's what the jury does with their time. Dan says, I'll never understand anyone leaving their social media up before testifying in a court case. It probably just doesn't occur to them, but probably doesn't occur to them. Crazy Cat Queen became a member. Thank you. Rihanna says, why is my attorney so happy that my case resulted in new case law being created in my favor? To be clear, this was separate from winning my case. Do I have to ask my attorney directly at $4.50 an hour? Yes. I can't honestly speak to why your attorney is happy or not. Obviously that's speculating, but if there was case law that was created to benefit you, I guess he's pretty happy that he was able to accomplish his objectives. So, I mean, that would be my best guess, but I don't know. I don't know what he's thinking about anything. Diego says, as a lawyer, do you reflect on what you're doing to help your customer? Meaning, does Ben Ronborn have any remorse to push a thing like he's pushing, knowing JD is a victim of DV? No conscience? Maybe I'm too naive. A lawyer is an advocate for their client, period. That is their role. Their role is to be an advocate for their client, to be a, what's the word I want here? To be a diligent and to be a, what's it called? To be a, I'm having memory problems because of tiredness. To be, basically, there's like a word I'm looking for that basically means diligent. I can't quite find it. But that's a lawyer's role, is to be an advocate for their client. Their role is to try to achieve their client's objectives through any lawful legal means that they want, that they can. Zealous was the word I was looking for. Thank you. I couldn't quite come up with it. For some reason, I thought it started with an F. And I couldn't quite get there. So yeah, zealous was the word I was looking for. A lawyer is to be zealous. Thank you. Yeah, zealous is the, don't ignore chat. I'm not ignoring chat. I'm doing, what are you talking about? Anyways, so a lawyer is to be zealous. A lawyer is to be diligent. They are to be the advocate for their client's goals. So, like, the question for a lawyer is, how can I advocate for my client's goals? Because I am my client to some extent, at least. Like, I stand in their shoes. I am their advocate. So it's like, whether Johnny Depp is a victim of domestic violence or not is technically irrelevant to the issues to be decided. I mean, it is technically irrelevant to the issues being decided. So, like, I can fully believe, if I'm Amber Heard's lawyer, I can fully believe that Johnny Depp is a victim of domestic violence, because that's not the question I'm trying to solve. The question I'm trying to solve is whether or not, you know, he defamed Amber Heard. Whether or not he's a victim of domestic violence or not is irrelevant. So it's not material to my analysis. So my job is to advocate for my client's position. And so, you know, that's all there is to that, really. And says, no BS. What do you think the biggest hang up the jury is going to have? Who will win the trial and what damages will be awarded? I mean, I don't know the answer to this question, obviously. I'm not trying to BS you, and I'm not trying to be difficult. As I honestly don't know. Because every jury is a very dynamic thing. Every jury has a life to itself. No two juries would go about it the same way. You know, you could put any seven, you just think about it for just a second. It's like, do you think if you took any seven people, even in this chat, even from pro John and Depp people, do you think you could take seven random people, even from team Johnny Depp, do you think you could take any seven random people and put them in a room and have them have the discussion, and it would be the same discussion as any other seven random people? And the answer is no. Like, even if they ultimately came out the same way, like, the discussion they have is going to be different. The paths they take are different because the people participating is different. What they're saying is different, right? So every jury is a creature unto itself. So one of the reasons I can't answer your question is because what will this jury choose to care about is a completely impossible question. What lawyers think the jury will care about is often not what they care about. Our experience collectively as lawyers tells us that sometimes the jury focuses on what we would be perceiving as completely inconsequential details. So juries often surprise us by their mechanisms. So I'm not trying to be difficult. I just honestly don't know what this jury will choose to care about or not. Who will win the trial? I really hope Johnny Depp will at this point. And what damages will be awarded? I don't know the answer to this question. I think Johnny Depp has justified his ask, but maybe the jury thinks some of it's too speculative. I mean, it's literally up for the jury to decide. They are, and once again, the finder of fact. How much has he been hurt? So, like, I don't know. Maybe they'll put all the numbers in a hat and average it out. Bev Libra says AH has most likely demanded her swan song. Probably. Swell Guy says, why couldn't Johnny Depp keep it together after all this? Lindenso said, what charity would you donate $7 million to? Well, first of all, I don't have anything like $7 million, so I can't donate $7 million to any charity. But if I had a random $7 million just sitting around, then the first charity that comes to mind is the Foundation for Individual Rights in Education, also known by their acronym FIRE. The Foundation for Individual Rights in Education is a charity which deals with First Amendment issues on college campuses. Many college campuses, because of wokeness and other reasons, have made it difficult to have freedom of speech on campuses. Now, for public colleges, for private colleges, obviously they can do whatever the hell they want because they're private colleges. But for public colleges, they're arms of the state. So they're the government. Public colleges are the government. And the government can't restrict freedom of speech. It's in the First Amendment, don't you know? So, but a lot of colleges do, out of sensitivity and all the rest of it. Like, we need to have safe spaces. We need to prevent people from, making people uncomfortable. Right? So a lot of campuses take a very dim view on the First Amendment vis-a-vis like any other arm of the government. So the Foundation for Individual Rights in Education, FIRE, is an organization that does exactly this. They fight for freedom of speech on college campuses. They are of the opinion that speech is good and people on colleges should have speech. So that's the first organization that comes to mind. Other candidates that I would be partial to include the Center for Democracy and Technology, the Electronic Frontier Foundation, let's see, who else would be like on the top of my list? That's about it. Can Johnny be called back on the stand? I guess technically, yes. I'm not sure why you would. Young, love your coverage of the case. Is tomorrow the last day? Yeah, last day for arguments. When will the decision be made? Jury gets the case on Friday. I'm betting they have a decision on Friday, but we'll find out. NM says, if AH decides to go self-destroy, what remains of her case and takes a stand? You go on for 7 hours with Ben Chu or Camille Vasquez? I think it has to be Camille Vasquez, technically, because Camille Vasquez did the original cross of Amber Heard. The rule is one horse, one rider, right? So you get the same attorney, you get the same attorneys for that witness forever for that case, right? So I think by rule it has to be Vasquez. So you would get 7 hours with Camille Vasquez. So that should be fun. Emily Skinner, when does your background music start for discussing a case? I don't know. It just does it sometimes. Last night was awesome and set the vibe. We need more of this. No offense, I like feisty, but you truly are the best. Love your insight. It's fair. Awesome. Thank you very much. Crazy Cat Queen gave $50. If Amber Heard loses and she already paid $6 million, does she need to pay her team more for appeal? Yes. Or is it included? Well, I guess strictly speaking, it depends on their retention agreement. But I would imagine the appeal is going to be separate. Can they fire her for manipulate evidence and perjury? Not at this point, no. They're stuck with her till the bitter end. Whatever that is in terms of the retention agreement. So I imagine they're free. What if she can't pay? Do they just eat the cost? Depending on the agreement, yeah. Right? And like if they wanted to quit today, it's like if she ran out of money, they're not going to let them quit today. So yeah, possibly. Montana says, would 50 million be too much for a jury to decide based on socioeconomic status? I don't think so. Northern Virginia is one of the richest areas of the country. Fairfax is pretty rich. It's one of the richest counties in the country. I think it's like Fairfax is like the 5th richest county in the country. And like neighboring Loudoun might be the richest county in the country. I think they even beat like Beverly Hills in terms of like total amount of wealth. So I wouldn't think that socioeconomic, there are probably some people who have money, no money, come from money. So like, I don't think that would necessarily be a problem. Cronit said, have you ever thought of becoming a professor? Absolutely, love to. The F word I was looking for was fervent. I was looking for zealous. I was just nowhere close in the dictionary. Jennifer Jacobs, and thank you for what you do. Thank you. And Leanne gave $5. Thank you very, very much. And let's see if there are other super chats I missed. RC Kid and RC Car became a new member. Heather H says, appreciate your input and all the hard work you do into streams. Your realness is refreshing. Side, your shirt really brings out your eyes. Thank you very much. Jano gave $4.99. Kurt, since you're in Texas, thoughts on the recent school shooting and thoughts on gun reform in Texas? Well, I feel like that's worth a lot more than $4.99 if we're going to go into it on any level of depth. I will simply say that my views, well, let's just do it from straight legal principles. How about that? I'll just do it as a straight legal analysis and not worry about the rest. Anyways, so from straight legal principles, we've talked a lot about the Second Amendment before on my channel. I've talked a lot about my view of the Second Amendment. My view is, generally speaking, I think Heller was essentially correct in the Second Amendment construction. It allows people to have arms that are ordinary and useful. So handguns, shotguns, and rifles. I'd also take note, for what it's worth, that the total amount of rifle deaths in the United States is pretty low. I believe last time I looked, and these numbers could be off, but I believe the total number of gun deaths from rifles, all rifles, mind you, not just assault rifles, but all rifles, I believe is 4%. But the vast majority of deaths in the United States are due to handguns, for whatever it's worth. Anyways, and like the total amount of people who die from all rifles is less than the amount of people who die from like bludgeoning attacks, or die from stabbing, or dying from like even being punched and hit and kicked. So there's just like statistics, by the way, on the numbers of the thing. Anyways, where was I? Oh yeah, so the Second Amendment analysis, I believe, allows people to keep ordinary and common firearms. Probably, in my view, would disallow anything that would not be bearable by a person, which means usable by a single person. So I think the Second Amendment in its construction contemplates the person being able to carry arms themselves and, maintain the firearms with have some sort of familiarity with it. So I think the Second Amendment, therefore, in my view, excludes any sort of like crew service weapon, or a weapon that would require, multiple people to move. It would have to be something that would have to be usable and bearable by a normal person. In my view of the Second Amendment analysis, Nick Rikita, for what it's worth, disagrees with me and thinks the Second Amendment goes further than this. This is my honest opinion of the construction. I think Heller was essentially correct in its construction, therefore, about the nature of the weapons, ordinary and common weapons, I think is essentially correct. I think, therefore, any sort of, in my view, therefore, you say Heller? Yes, Heller versus DC. Yeah, Heller versus DC is the case. And the other case you should look up is McDonald versus Chicago. Those are the two big gun cases that exist at this point. Heller versus DC and McDonald's versus Chicago. They're both great cases, well written, and worthy of your time. So I think any sort of gun, if you were going to view this from a purely legal angle, which I think is probably a good thing, all things considered, I didn't do a very good job blending the powder on my face. You can see discoloration from the powder. Didn't apply evenly. I need to work on that. I'm not really great with the application of makeup. I'm learning. Anywho's, where was I? Right. So any sort of restriction you'd have to post would have to be conform to the restrictions that the Second Amendment would require. I think also it's worth noting that I don't think the Second Amendment is truly unique in the context of sort of the costs it causes. Perhaps the costs of the Second Amendment are more visceral in some respect, but all the constitutional rights come with trade-offs. They all do, to some degree. And there is a conceit that these trade-offs are worth it. Like, for example, just to make things obvious, right? It would be a lot easier to convict people if they didn't have the right to remain silent. It'd be a lot easier to convict people if they didn't have a right not to incriminate themselves. It would be a lot easier to convict people if they didn't have the right to an attorney. You know how we keep talking about how courts are, you know how everyone keeps talking about how courts are not really a truth-seeking exercise because of all these rules. It's like they're not truth-seeking exercise. You know what really hurts with the truth exercise? You know what really hurts with the truth-seeking exercise? The Fourth Amendment really is a pain in the ass when it comes to the truth-seeking exercise. You know, if the government could just go into anyone's home at any time and just seize the evidence, or go into wherever and just take the evidence, that'd be great. You know, they could just go into someone's home and they could take the evidence and they could use it, and so many more bad people would go to jail. Then we would also not have to worry about any of those suppression issues anymore. We wouldn't have to worry about the fact that the police screwed it up and the evidence is not being admissible into court because the police screwed it up, which goes against the truth-seeking exercise portion of court. It'd be a lot easier if we didn't have the Fourth Amendment. You know, we could go into their houses and search stuff, and you know, we never have evidence thrown out of court ever. That'd be great. You know, what if we didn't have a prohibition against cruel and unusual punishment? That'd be good. You know, because, you know, maybe if we really punished people like really hard and basically tortured them to death, maybe that would work in preventing people from committing crimes. It would certainly send a message to me. You know, send a message to me. I think that Eighth Amendment cruel and unusual thing, that's a pain in the ass. We don't need that. You know, it really would be nice if the government could just, you know, build roads anywhere they wanted to, and because the roads help us all, don't you know? And you know, if the government has to pay for the land they use, that hurts all of society. I mean, it's just this one guy's land. No, why should he have the right to have the land? Why can't we just pave the road over it? And it's for the public good. So why should we pay him anything? That's an inconvenience to the taxpayers. Literally, it's a cost. It's costing us money. We have to pay him for that land. What if we didn't have to pay him for the land? That Fifth Amendment eminent domain provision is a pain in the ass. What if we didn't have to pay him for the land? We could just not pay him for the land. You know, what if we just didn't have trials at all? What if they weren't public? What if we didn't have public trials? That'd be convenient. They could just be done in secret. And people, and we don't have to have a jury. That'd be good. We could just have secret trials, and they wouldn't be open to the public. And you know, that would be good. I think that would probably result in a lot more convictions, and so forth and so on, and so forth and so on. So the point I'm trying to make here, in case you missed the point, I'll say it again. The point I'm trying to make here is that while the Second Amendment's protections have cost, they also have benefits. And the benefits, I don't have to walk you through. I mean, you're smart people, you can figure it out. But, you know, the risk of pointing out the obvious: self-defense, defense of others, defense of the state, defense from the state, right? So the Second Amendment has a point. It has benefits, but it comes with costs. These costs are more immediately obvious, in some senses, in the death of so many young children in a horror show of depravity. But don't fool yourself. Don't fool yourself into thinking the Second Amendment is the only one that comes with these costs. They all come with costs. they all of them, by their nature, all of them place the individual above the collection of society. All of them. All of them are placing the interests of one person above the interests of 350 million people. They all come with costs. Not all of them are obvious. And not all of them are monetary. So that's sort of my thoughts on the whole thing. I think that everyone's outrage at the shooting in Texas is worthy, is obviously understandable. There is an individual who did this. There's an individual who did this. And that individual is presumed innocent. That person at this point in time is innocent. He is innocent under the law. And, there is some chance, although, who could say at this stage, but there is some chance in some remote future that for whatever reason, he might be found not guilty. Because we as a society have made decisions in advance with neutral rules in advance, and we've decided that certain principles for us are more important as Americans than is he dead? Okay. All right. If he's dead, then fine. I honestly didn't know either way. So, okay, we'll go. How about Ethan Crumbley then? We'll use Ethan Crumbley instead because he's still alive. There's some non-zero chance that he won't be convicted. So, and there's a very good chance, in my opinion, that his parents won't be convicted. In fact, under the law, I'm not sure they should be convicted. That's another discussion for another day, but there's a non-zero chance that Ethan Crumbley will be found not guilty for any number of reasons. But we as a society have decided in advance of all these things that even though there's a possibility a monster might go free, in the end, in the collective balance of things, it's worth it. And so I think it's good to remember that freedom isn't free in every possible sense. Freedom comes with costs. And those costs need to be considered in some sort of honest way. And just because the shooting is so immediate and so visceral and so obvious, I don't even think necessarily makes it the most costly thing in balance. I think you can make a better than credible argument that there are other provisions of the Constitution which are more costly to the society as a whole than the Second Amendment. Maybe those costs are not as obvious, they're not as visceral, they're not as immediate, but I think you can make a better than credible case that some of the provisions in the Constitution are more costly to society than the Second Amendment. And I think you can make a credible case that all those rights are worth it in the end. Yeah. So Leanna says children's lives are not a valid cost for anything. Okay. Let's take that literally. Let's take it literally and follow it all the way through. Let's take the proposition. Children's lives are not a valid cost for anything. All right. Let's suppose that person A, where I'm going to tell you in reality, in actual matter of fact, person A has killed a child. In actual reality, in actual fact, he is, if everything were perfect, he would be convicted under the relevant law. Okay, I'm just declaring it because it's my hypothetical and I can make it up. Person A, in fact, is guilty of killing a child. In fact, we'll even go one better. How about that? He's guilty of killing 10 children. Is it at the same time, or is he a serial killer? I don't know. It doesn't matter to my hypothetical. Take your favorite point. He's guilty of killing 10 children. He has, in fact, murdered 10 children. Okay, how far are you willing to go with this principle of children's lives are not a valid cost? How far are you willing to go? Are you willing to deprive him? It's your world. You tell me. Are you willing to get rid of the provisions in the Constitution that prevent a person from that say a person can't incriminate themselves? Do you think what we should be able to compel him to incriminate himself? Do you think we should get rid of that prohibition? How about a trial by jury? Should we get rid of that provision? Is it worth it? I mean, if he has a right not to incriminate himself, when the police arrest him and say you have the right to remain silent, he might say I want to remain silent. What if he didn't have the right to remain silent? What if he just didn't have it? Not every country does. Not every country does. What if he just didn't have the right to remain silent? What if the police could hold him and he couldn't remain silent? What if he didn't have a right to a lawyer? But what if he says, I want a lawyer, and he's going to get away with it because even though he has in fact killed 10 children, for whatever reason, because it's my hypothetical, the government can't convict him. I mean, they're pretty sure it's him for a whole number of reasons, but for whatever reason, because it's my hypothetical, they can simultaneously know it's him, or at least be confident, and they don't have enough evidence to convict. His confession would be really nice. So is his right to remain silent worth it? Is it worth it? As it turns out, this guy who kills 10 children, he's just a really, really likable guy. He's just really, really likable. People gravitate to him. And man, if he had a jury of 12 people, man, he might make a connection with one of those people. That would be bad. What if we didn't have a jury? Is it worth it to have a jury? Is it worth it to have a jury that might assess this? It could come to the possibility of this. Hi, John. We're trying to determine if the Constitution is good or not right now.
Oh, I got the bat signal right there. The second you started going on that point.
We're trying to determine if the Constitution is good right now or not. John, we're having a recent debate about whether the Constitution is a good thing, because the Constitution has some things that might make it hard to kill child murderers.
Yeah, last I checked, 246 years. Not a bad track record for a constitution in this world.
Yeah, but that right to remain silent is a bit of a pesky thing. Miranda is a pain in the ass, right? I mean, Miranda is a pain in the ass. We have to, not only does he have the right to remain silent, but we have to tell him he's the right to remain silent, and he might actually do it. So what if we just, rather than just strike down Miranda, what if we just got rid of the Fifth Amendment? I mean, let's go bold, right? I mean, that'd be great. The police could just hold you and you wouldn't have the right to remain silent anymore. And while we're at it, we'll get rid of the Sixth Amendment, so you don't have a right to an attorney.
Yeah, so no fifth, no sixth, no fourth. Yeah, and we're just in a police state.
Yeah, there would have been, but hey, it says right here.
It would save lives.
It would at least hold those who commit the crimes accountable. I mean, it says right here, children's lives are not a valid cost for anything. So I guess we have to get rid of all those constitutional protections that help to protect bad people. They're all a pain in the ass.
So it's 2, 4, 5, 6, 8.
Mm-hmm. Yep.
Probably 9 and 10.
Yep.
So we just throw out the entire Bill of Rights.
Most of it, yeah. But we're making sure that we can get the people with the child murderers, because children's lives are never a valid cost for anything. So I guess it must be true that all those provisions are not worth it.
Then why even exist in a legal state? Why not have a state of force? You want to go state of nature? We can go state of nature, but that's not going to.
There are countries like that. There are definitely countries like that, and there are countries that have been like that. I mean, there are countries still that are monarchies, absolute monarchies. I think Saudi Arabia still technically qualifies as an absolute monarchy, so they can do pretty much anything they want.
I mean, England still technically.
This is a straw man fallacy. Okay, this is great. We have to have a discussion with things. All right. So I want you to look at this thing on the screen. Children's lives are not a valid cost for anything. not a valid cause for anything. Then someone says this is a straw man fallacy. No, it's not.
No, it's not.
It's not a straw man. I am attacking the statement. The claim is it's not a valid cause for anything. So this is not straw man. I'm attacking their claim directly on point. Damn, learn how to use words.
No, again, straw man is one of the most used terms on the internet by people who don't understand what it means.
No, a straw man is where I take your argument and I replace it with a weaker version of your argument and then attack that, right? So your claim would be like, okay, I don't know. Your claim is like, we should, I don't know, shouldn't raise taxes on gum. And I say, oh, so you're saying we shouldn't raise taxes on anything, which isn't your argument. See, I've substituted one argument for another, and now I'm attacking the other argument. That's straw man. Here the claim is it's not a valid cost or anything. I'm not even sure how you theoretically would straw man that, because it's a pretty bold claim.
Yeah, I agree with you. Are you, Kurt, are you familiar with the medieval debate format?
Medieval?
Yeah. So basically the way that it worked was before you were able to respond to a claim, you had to restate the opponent's argument to their satisfaction.
Yes, that's a great rule.
And it's a great way of trying to avoid strawmans. And I don't think that you're doing anything like strawmanning the argument.
No,
I'm taking the argument at face value.
I'm taking the claim at face value. And I'm like, well, if it's not worth anything, here are some things that might make it harder to convict. I mean, I don't think anyone's going to deny it might make it harder to convict the bad guy because that right to remain silent. I mean, right? So it must mean that therefore the right to remain silent is not worth it. That is just a straight logical conclusion.
Right. By that argument, then fine. Yes, we can torture confessions out of people because who cares? Why do we need the Fifth Amendment at all?
Yeah. Right. So, I mean,
why do you need a lawyer?
Yeah. So I also love it because it came at the end of this fairly lengthy explanation where I'm pointing out that all the constitutional provisions come with costs because none of them are free. And one can make a credible case, to my mind, that there are other provisions in the Constitution that cost society more than the Second Amendment.
Certainly.
Yeah.
I mean, without going into the entire politics of it, you can make an argument that the idea that non-landowners can vote has had costs on society. You can go in so many different directions, but the idea is, yes, freedom is not free. It requires a trade-off that we've chosen, and chosen in an overwhelming manner. And that's why, if you don't like the Constitution, there are mechanisms to change it.
These are bad faith arguments. No, they're not. They're not bad faith arguments. I am literally taking the statement literally at face value. It's not a bad faith argument. They said
Agreed.
It is not a bad faith argument. Learn to read things.
I absolutely agree. And I don't understand some of the opprobrium that's coming there, because yes, you're taking the argument at face value and you're responding, I think, perfectly appropriately.
It's not my fault they made an absurd claim, because it is an absurd claim. I mean, 2 seconds of thought tells you it's an absurd claim.
It should, but unfortunately, that's not the world that we live in anymore.
I don't know, man. Yeah. So we were discussing the Second Amendment. Now, have you heard my did you hear my view on the Second Amendment? I kind of went over it a little bit, but if not, I can go over it again.
I did not. If you can give me the
too long didn't read.
Dirty.
Okay, the too long didn't read is I said I think Heller was essentially correct that the Second Amendment extends to the arms that are in ordinary and common use, and also only applies to those arms that are bearable, by which I mean they would be carryable and usable by a single individual acting alone, which excludes, crew surface weapons and tanks and nuclear bombs and a whole bunch of crap. So that's basically the too long didn't read version.
Okay. I don't know that I necessarily agree with you on sort of foundational grounds, but that's not it's not a reading that I would quarrel with a lot.
Yeah.
My thought at the end of the day is when they're talking about bearable arms, they're talking in that circumstance, they are talking about it in the context of what was bearable at the time.
Yeah.
So if you're trying to say that that's the difference between tanks and nukes, okay, I can walk with you on that. I don't necessarily agree, but I can walk with you there.
Well, I mean, that basis wouldn't alone be sufficient, because then you run into the same problem you do with the First Amendment. Like the First Amendment, obviously, the First Amendment, when they're talking about the freedom of press, to my mind, first of all, they're talking about technology. So they mean literally access to the actual physical printing press is what they mean, in my view. Freedom of speech, the freedom of speech options are kind of pamphlets and newspapers and standing on a street corner. So and quills. So I if you run into this problem of like, oh, it doesn't extend to Facebook, I'm like, yeah, it kind of does by extension, by reason. So like, if you could find some sort of equivalent technology at the time that would be whatever the equivalent of a tank or nuclear bomb would be, then you'd have a reasoned argument by extension, by First Amendment parallels. I'm not sure how that would work exactly, but yeah.
So that's interesting, because you're almost kind of like a super traditionalist on that one then. Like the farthest flung form of traditionalism in terms of judicial philosophy.
Say that like it's a bad thing.
No, I'm not saying it's a bad thing. I'm just asking if that's where you sort of subscribe.
Yeah, I mean, yeah, basically, I think exactly so. Like the language of the First Amendment is embodying concepts like the freedom of speech. Well, as I've discussed on my channel, or the right to bear arms. Okay, first of all, the word
we have not always agreed on that.
Yes, this is fine. The word "the," in my view, is a specific article. It refers to a specific thing. So we have to go define the thing. What is the right to bear arms? What is the freedom of speech? So now we have to go define that and whatever its boundaries are. And so now we have to have a discussion. And so if you're thinking about, like, for freedom of speech angle, for example, about freedom of speech, you're like, okay, what were they contemplating? Well, they were contemplating newspapers and pamphlets and, writing letters and standing on, soapboxes and giving speeches in parks. And this is about the exhaustive list of things they were probably considering. So it's like, okay, is that all that it means then? It's like, well, now that'd be a little bit dumb, but we can take the same concept and we can extend it by modern extension of what they were trying to capture. So it would include, because fundamentally, like at the end of the day, there's really no difference on like a logical level between Facebook and a newspaper. It's both written words and a medium, and you're sending it to somebody, so why not?
So let me ask a question. If you go to the Second Amendment and what they were contemplating, at that period of time, you had the Girardoni air rifle, which was capable of holding, I think, 16 rounds.
Mm-hmm.
You had pepperbox revolvers that had 28, 32 rounds. And all of those were known technology at the time.
Mm-hmm.
And all of those were bearable by individuals.
Mm-hmm.
So would you agree that if we go with your principle that you have a right to bear an arm that an individual could carry, that, yeah, practically speaking, magazine limitations probably violate the Second Amendment?
Yeah.
Okay.
Yeah, that seems logical, because the reason that you have the pepper box with as many is just a technological limitation. It's not it's not a limitation based in some sort of legal theory. It's not like they said, wait, we have 16 in the pepper box, but not 20. That wasn't the thought that was going through their mind. So yes.
So let me push you a little bit further on arms that individuals can carry. Because if you go to, I guess, what was it? I forget if it was Madison or Jefferson, the letter of marque and reprisal, saying, yes, you can absolutely carry cannons on your merchant vessels, non-military ships. But yes, absolutely, the Second Amendment. Why are you even asking me this?
Mm-hmm. Yeah, so it's a very sharp question, and it's a good question, because it is a question I get pushed back on, because, as you point out, the Constitution does provide for Congress being able to issue letters of marque and reprisal, and just basically allows them to have privateers, basically private armies. I mean, for part of, because like, you know, I think well, first of all, I don't think the Second Amendment and that needs to necessarily be read together. I think the Second Amendment could be talking about different concepts. The fact that like merchant ships were doing this at the time, and there were what you might call privately armed ships of war. I mean, mercenaries are kind of a thing to some degree, even now, perhaps even more now. But I don't really think that's what the Second Amendment was contemplating, in my view. I think, because also I don't think you can view the fact that Congress can issue letters of marque and reprisal as providing individual right that would allow someone to invoke against it. It'd be a little bit like saying, okay, on Article 1, Section 8, Congress has the right to create postal roads. Okay, what if Congress just, didn't? We don't like post offices anymore. They're dumb. It's like, well, I have a right that I can individually invoke now to say, I must have postal roads. It's a power of Congress they can or cannot use. So I think the same is kind of with marques or reprisal.
But that goes back to sort of the Heller analysis and the super chat that just came in. 2A starts off talking about militias, then says the right of the people, not a person, to bear arms shall not be infringed. The issue is that
that I don't have a problem with, because this, when you talk about people, it's the same exact language in the other provisions of the Constitution.
Right.
So,
the operative clause is the right of the people to keep and bear arms shall not be infringed.
Sure.
Period.
Right. Yes.
So the question then becomes, what are acceptable limitations on that right that's being recognized by the Second Amendment? And
yeah, well, I mean,
it's a little tough for me if they're saying that private merchantmen can carry cannons, which was probably the strongest artillery available at the time. Then what is the legal limitation what is the limitation that's not contemplated by the individuals that ratified the amendment?
Yeah. So let me address the original thing, and then I'll address your question. So yes, it talks about the right of the people, but so does every other provision in the Constitution. They all talk about people, plural. So I think that from this position, you'd say that all the rights are collective, and which doesn't make sense. I think they're all individual rights, so they belong to each and every one of us. So the fact that it talks about people is not a problem in this context. To go to your question about what are the limits, we have to define two things. It seems to me in the operative text, we have to define first and foremost what is the right to keep and bear arms, because whatever it is, it almost certainly is not the right to have any arm, any time, in any way, in any manner, in any purpose, by anybody, like any more than any other provision of the Constitution is read that way, right? It has to be understood within its constraints, and to understand its constraints, you do the kind of same thing you do for freedom of speech analysis. You go back to common law and figure out what the right does and does not include. So, for example, the freedom of speech does not include defamation, because it never did. It was never thought to be included within the freedom of speech. So you can either view it as an exception to freedom of speech, or my preferred idea, it's just not in the concept of freedom of speech at all. It's just not a thing. It's not within the boundaries of this thing we call freedom of speech. It might be spoken, it might be written, but it's not within the freedom of speech, because it never was. It's not part of the defined territory of the freedom of speech. So, likewise for fighting words and blah, blah, blah. So for the Second Amendment analysis, same thing. Like, we have to go first define what is the territory of the right to keep and bear arms. So just because it's an arm does not necessarily imply it's within that context, because you have to have a more nuanced discussion in my mind. You want to interrupt me?
No, I'm listening.
It sounded like you wanted to interrupt me, so I wanted to give you space.
No, I don't necessarily agree with your analysis on the First Amendment, but I will let you go, and I'll respond.
Okay, if you don't agree
finish
with
your
my
thought.
analysis on the First Amendment, then this all kind of falls apart. So maybe we should address that now.
Okay. I mean, again, I think that I'm pulling up the actual language. Yeah, so I think that there is a semantic difference between the First and Second Amendments.
Mm-hmm.
And let me pull the second text.
You can share it if you want. Share the screen. Share the tab. I'll be happy to put it on screen so everyone can see what we're reading. It's always good to go back to the original text. It's a great place to start.
Let me see. Let me see if I can just pull up the Bill of Rights and I'll share it.
While he's doing that, let me just read a couple super chats real quick. J.R. Callahan will donate to Fire Kurt, usually donate to Kinky Freeman's Utopia Animal Rescue Ranch for years, but it ended. Visited there several times in Hill Country. Well, thank you. From Jason Wharf, I did not think the Depp's texts were bad. Trauma victims often forget things as a result of trauma. Advance for Depp, maybe in closing, I don't think it's that much a problem. I don't think it was great for him, but I don't think it really hurt them that much. AP $5. Any props to the judge for not being a point of controversy? I think the judge is a great judge. I disagree with some of her legal interpretations, but she's applying them consistently, and that's what you really want from a judge at the end of the day. Ann Laurelson, thank you, Kurt. I really appreciate your time and honesty. You're welcome. Cammy became a new member. Thank you very much. In Exile, 499. Love your principal takes. Thank you. Clouchman, 999. It doesn't seem fair that JD's strategy saved time and Amber Heard didn't, but they get 5 minutes per witness. Well, it may not be fair, but it's the law. And like everything, we're constrained by the law. To be fair, should the judge give JD's equivalent the equivalent of 5 minutes per witness? No, I don't think so. It's just the law. It kind of sucks, but it is what it is. Stargate says, have you read Florida East Coast Railway? It's been a long time. I completely forget what the case says. Susan Murphy said 25. Susan Murphy said, thank you, Kurt. Your arguments are so great for the Second Amendment. Love that you believe in our Constitution. I try. CBL 1999 for your kindness and support of Legal Bites. Thank you. And the other author, 1999. Second Amendment talks about taking on malicious says the right to people to bear arms shall not be infringed. How are you getting to say it only protects weapons bearable by an individual? Well, as to the bearable part, because it literally says keep and bear. So I'm interpreting that to mean weapons that are keepable and bearable. I think that operates as a operative restraint on the text.
That's little bit of legalism, but okay.
That's what I do for a living. That's how I roll. I roll deep.
All right, so I don't know if I'm going to be able to share effectively, but I'm going to compare Amendment 1 to Amendment 2.
Great.
So the first one says Congress shall make no law respecting all of the things.
Mm-hmm.
I think a difference is that the operative function when it comes to the Constitution is at the end of Amendment 2.
Mm-hmm.
Does that make sense?
Yeah.
So shall not be infringed is a very different statement than Congress shall make no law.
Yeah,
and
see,
so I think that there is
I never really thought they were that
break
different
between those two.
What do you think the difference is? Because I never really thought they were that much different. But what do you think the difference is?
One is actually a commandment by the Constitution against Congress passing laws. The other is a restraint upon Congress. There's a difference. One is an operative order. The other is a restraint against an individual right. So you see where it says, where Congress shall make no law respecting the establishment of religion, prohibiting exercise thereof, or abridging freedom of speech, or of the press, or the right of the people to peaceably assemble. And the people only ever come in terms of peaceable assembly. Otherwise, it's literally everyone has that individual right.
Okay.
The
Fourth Amendment talks about the right of the people, though, for example. So yes. I still think that extends. I mean, it still extends.
But notice how that does not exist in the Second Amendment.
No, I was just saying that the people part doesn't really mean that much to me.
Okay, that's fine. My point is that shall not be infringed is a thou shalt not pass kind of prohibition, whereas proscribing Congress from making certain laws I think is actually a weaker protection than saying not be infringed. Because infringement is literally any limitation.
I'm thinking. I'm not sure there's a distinction because all Congress can do is pass laws. So what would be a thing Congress could do that would be infringing other than by passing legislation?
Tax it.
Yeah, but
which already exists, but
you already got that concept in the First Amendment analysis kind of too. I'm not sure. I'm not really sure there's a.
You don't have to agree with me.
I'm trying to really understand your argument. I'm trying to fully understand your argument before I disagree with it completely, because I want to actually understand what I'm agreeing with or disagreeing with, because I want to give it fair consideration. So I'm a reasonable guy.
Sure. I think there's something fundamental. They use different words. Shall not be infringed versus Congress shall make no law, I think, are different words used for different purposes. That's kind of the core of the argument, and I can expand it from there if you'd like.
Well, I mean, you do have a sort of basic principle of statutory construction, and the Constitution is, after all, a statute. It's just a really important one because it's the prime law. But I think it's the same analysis. But you do have a principle of statutory construction where, like, you use the same words to mean the same thing and different words to mean different things. And if they use different words, it's probably because they mean different things. And it's probably a mistake to interpret different words to mean the same thing, all things being considered. So, I mean, you do have that point going for you that I probably should try to find a distinction between Congress shall make no law or shall not be infringed, because obviously Congress knew how to write one and could have just copy and pasted, and then he didn't. So the default presumption should be probably that they meant different things. I'm just not sure what that is.
I know. I'm proffering an interpretation. I'm not saying that mine's right. I'm just saying why I think that the two should be construed differently.
I'm open to the possibility.
It's sort of interesting that prior to Heller, there had been virtually no litigation about the Second Amendment.
Damn straight. Last real case was Miller, which is a trash fire of a case.
Oh, absolutely. So I think everybody basically understood what the Second Amendment was talking about until modern circumstances changed the calculus.
I can tell you that, like, there was every court of appeals basically forever said it was a collective right and everyone should go away. So
yeah, that's true. And every court of appeals, turns out, according to the Supreme Court, was wrong.
They're all wrong. Of course they're wrong. I can read.
Yeah,
we're having slight. Well, I don't know if we're having a disagreement at this point because we're having more of a discussion. We're having a discussion over exactly what we're reading, but I'm like, well, it means something.
Well, and that's always what's interesting. And I think Scalia did a very, very good job of explaining the difference between a prefatory statement and an operative statement.
Yeah, I like that too.
And if you left it to the liberal justices, they would actually believe that it was just a militia's right to arm its people.
Yep.
Which would be absolutely insane to the founders.
Yeah, not for least reasons, because, like, the Militia Act, like 1793, I think it is, the Militia Act.
I believe so.
It's, what is it? All able-bodied males between 17 and 45, if memory serves correctly, basically can be called up to service. So, like, still technically at this point, by law, I'm technically a member of the unorganized militia.
By that logic, so am I.
Yeah, I'm running out of time, but, you know, I'm still within the bands for the moment. So,
well, and even when you talk about, magazine limitations,
mm-hmm.
It was Congress that gave the Giordani air rifle, which had 16 rounds, to the Lewis and Clark expedition.
Mm-hmm.
I mean, you can go back to history and explain all of these circumstances. There was, I forget who, but there was a gunsmith in Philadelphia who was able to essentially have a repeating rifle.
I seem to vaguely remember that.
That would fire 12 or 14, 16 shots, whatever the hell it was. But the only reason they didn't take him up on it during the revolution was that it would be too expensive. But otherwise, they were totally cool with that.
Yeah. Yeah.
So I don't know where there's no principled line that they're drawing to one. There's no principled line that would stop, say, the case in Texas, which is obviously tragic. And I don't want to take anything away from that. That is a tragic circumstance.
Right.
But there is no principled legal line that you can draw there that's going to make a difference without eviscerating the fundamental rights of Americans.
Yeah. So I'm open to the possibility that shall make no law and shall not be infringed mean different things. I guess I'd have to have an example of where it would make a difference between the two for me to really fully grasp the concept. But I'm open to the possibility. But still, either way, like, we still have to do two things to my mind. And like, okay, but all right. So as to the freedom of speech, do you disagree with my analysis about what the freedom of speech is in terms of its own boundaries? Do you disagree with me in sort of disagreeing with the concept of defamation is not the freedom of speech because it is not within the boundaries of the freedom of speech? In so much as we're trying to draw out boundaries of a piece of land, it is not part of the land of the boundaries we're trying to draw.
I'll agree with you on that.
Yeah. So that's sort of my view. So I mean, yeah, you could view defamation as an exception to the First Amendment, but it's kind of like whether
no, it's not First Amendment in the first place.
Yeah,
I agree with you in that analysis.
It's kind of like saying, is it a hearsay exception or just not hearsay at all? To go to our friends of the federal rules of evidence when it comes to So, anyways, to me, it's like not that it's a First Amendment exception. It's just not in the First Amendment. So, the freedom of speech the boundaries does not include defamation. Okay, fine. So if we're agreed as to that much, then I have to still do the same thing in the Second Amendment. I'm still talking about the right of the people to keep and bear arms. So still the same. Like whatever that is, I have to go find its boundaries before I can even talk about it being infringed. I mean, you can't talk about being infringed without having to, I can't talk about trespassing on a piece of land without knowing what the land is first. I got to define it first. So,
all right. So you're going to apply that to the Fourth Amendment, the right of the people to be secure in their person's houses, papers, and effects.
Hell yes.
Only applies to persons' houses, papers, and effects.
I have no problem with that. Well, persons as well, because persons, houses, papers, and effect, that's four things. The people are secure in their own persons as well. You can't seize a person.
I read it verbatim.
Yeah. Okay.
So the right, is that constrained by some historical purpose?
Absolutely. In so much as you're trying to understand the right of the people to be secure. Yeah, absolutely. In my view.
Why did they say that against unreasonable searches and seizures? Because presumably if a warrant is issued, then it's a reasonable search or seizure. Like there are self-regulating aspects of most of the Constitution.
Yeah, I mean, okay. Well, I think either I'm not being clear.
Maybe not most, and maybe I'm misunderstanding you, and I don't want to misunderstand you.
No, and I might, maybe I'm not explaining myself correctly, or maybe I'm not. I think maybe we're talking past each other. So this is still like a two-part analysis, right? To my mind. So the first thing we have to decide, to my mind, is what does the right of the people to be secure in their persons, houses, papers, and effects mean? That's step one. So yes, we have to do the same thing. We have to go through the common law analysis, and we have to figure out what are the boundaries of this right of these four aspects. What are the boundaries of this right? Once we've defined the boundaries of it, then we move on to step 2, against unreasonable searches and seizures. So this is the nature of the right, but we have to define the right first before we can get into any kind of discussion about what's reasonable and unreasonable. Because if it's not within the bounds of the right at all, then we don't have to go to part 2. We don't have to discuss what's reasonable or unreasonable if it's not part of the right of the people to be secure. If it's outside it, we don't care. Is that better? Am I making sense? No? Yes?
I'm following what you're saying. I think it's just a philosophical difference, because my reading of the Constitution is based upon Lockean principles of, what is the state of nature, what is the state of peace.
Locke kicks ass.
And again, if you go to 10, I think 10 sort of undercuts your argument in my mind, because the whole idea is that these rights pre-exist government itself. We're not endorsing that. We're not endowing them. We're endorsing them.
Yes, I agree with that.
So the idea that you're taking a legalistic perspective toward these pre-existing rights is really difficult to me, because I think that these rights exist pre-law. They exist on a philosophical basis, the classic Nick Rekieta. You survived the abortion mill, you were born, and you get these things. We're just recognizing them. We're not giving them to you. And I think that's exactly what Amendment 10, which has been utterly under-litigated, in my opinion, and the Supreme Court never wants to touch it because it is the
Supreme
third
Court
rail.
says it's just a truism.
It is a truism.
Yeah, so there's really nothing to litigate in my mind, because anything you could do under the 10th Amendment, you could just do under enumerated powers and call it a day.
In theory, yes. But I think that the 10th Amendment does actually suggest that when your theory of the right in a legalistic sense is not what was designed in the thought experiment of the Constitution. It's a weak argument, and I recognize it's a weak argument. That's my philosophical backing.
Okay. All right, let's see about this. I agree with you in some parts that it pre-exists. Well, it certainly pre-exists the Constitution, because we're talking about the right, so it must pre-exist the Constitution, because we're talking about something that has an antecedent basis. So it necessarily pre-exists. So something that we're recognizing or endorsing rather than creating. I think this much is true.
Yes.
I guess the question still is, like, what is the nature? What are the boundaries or limitations or nature of the thing we're recognizing? So the freedom of speech pre-exists the Constitution, no doubt. The question becomes, I think it's unavoidable to some degree. If you want to base it on something other than common law, or you want to go somewhere else, I think fine, but you still have to define, using something, what the freedom is you're recognizing. You have to understand what it is you're endorsing, and that has to come from somewhere, right?
Okay. And I'm not gonna disagree with you on that. I think that you're putting a lot of emphasis on literally the article "the."
Yes, I am.
And I think, personally, I think that's misplaced, but I'm willing to go there with you and suss out what their results might be. But the free exercise of, prohibiting the free exercise thereof, or abridging the freedom of speech.
Mm-hmm.
So is the fact that there's no "the" in front of establishment of religion, does that change your analysis of what the establishment of religion might be, as opposed to the free exercise thereof?
It would necessarily have to from this flow. See, I've never thought about this question before, but that's a very sharp question because yes, it would necessarily have to because it's A, right? It's A versus the. So A, establishment of religion. So now I necessarily have to change my entire analysis about what an establishment of religion means versus the prohibiting the free exercise thereof. Yeah, I have to now do something completely different for that part of the clause. Yes, under my construction. I don't know what that is yet because you just brought to my attention just now.
And you don't have to,
but I have a problem.
That's why I think that the hyper focus on that article, it causes problems in the analysis.
Yeah.
I'm not trying to throw you off your game.
I mean, I guess it kind of makes sense because if you said the establishment of religion, that might be more narrowly construed than what we currently have because you might understand it to be the nature of whatever established religions looked like in England. And even to this day, I mean, technically speaking, unless I'm mistaken, I believe technically speaking, the UK is still a theocracy.
It's a borderline theocracy.
I mean, technically, because right, I mean, the still it's the Church of England and the Anglican Church, and it's the king or queen. So technically, that makes it a theocracy. So
yeah, so the monarch is also the leader of the church.
Yeah, so technically makes it a theocracy, which is hilarious. So if you said the establishment of religion, it might mean only that kind of relationship with that kind of tie. So a establishment might be it suggests a much more open concept. It suggests a broader protection, which is probably a good thing.
Except prior to the 14th Amendment, for instance, the colony of Maryland and the state of Maryland was a Catholic colony and a Catholic state.
Well, I mean, I don't have a problem with that part.
So prior to incorporation,
yeah,
there was no issue with establishment of religions within the states.
Oh yeah, I mean, no problem. I mean, but that's easy enough. I mean, the First Amendment says Congress. I mean, I can read that too. So I mean, yeah, it obviously didn't apply to the states before the 14th Amendment. So yeah, no problem. Right.
Yeah.
Correct. But then whatever was true of the federal government, at least under the 14th Amendment conception, whether you go to the privileges or immunities clause, like I wish I could go, or I have to do the substantive due process bullshit. But either way, it's like, yes, whatever was true of the federal government is now true of the states. So now just copy paste. Like, great, no problem.
Well, and I think you and I both agree that the substantive due process bullshit is exactly that. All right, so that's an interesting. So establishment is written to be broader than free exercise.
I mean, I've literally been thinking about this for 3 minutes, but that's my first gut instinct and sort of trying to parse it out. So I
would love to come back and talk about.
I reserve many rights to revise on that one.
No, I'd love to come back when you have a chance to think about it. But I think it is interesting because, as I said, you put a lot of weight on that one article, and
yeah, I mean the second amendment still does the same trick too, because it talks about a well-regulated militia versus the well-regulated militia. So again, and if I apply my
it would operate the same way by that theory.
If I apply my brand new First Amendment analysis to my Second Amendment analysis, then again, militia would be a much more amorphous concept under this construction, which works with my Second Amendment analysis. So I'm not necessarily opposed to it.
All right, so by that logic, then yes, again, it's a prefatory statement on the Second Amendment. I didn't love how Scalia did it, honestly.
I didn't really love the whole paragraph about these presumptively lawful things. That wasn't so super great.
Yeah,
because the Court of Appeals been riding that horse like crazy, man. They love that paragraph so very, very much. It's like their favorite thing.
Yeah, absolutely. But honestly, after McDonald, that a lot of that, I think, kind of went away, because that was a real double down from the court.
Yeah.
And with the New York case, I thought that I was very disappointed in the court when it came to the New York case. I don't know if you covered it at all, or but
I did. I definitely did. We did the oral
they
arguments.
absolutely dodged the case.
Oh yeah.
And then they went right back and did it.
Oh yeah, the first time it was brilliant. It was brilliant.
The first time, sure, but the second time, like, at some point, you need to be admonished.
No, they're not going to be able to pull that again. So, yeah,
we'll see.
Yeah, let me read the rest of these super chats and try to call it a night so we can do it all again tomorrow. I do appreciate you being here, John. It's always nice to have someone intelligent who can help me think.
No, it's a great time, and I'd love to hear what your thoughts are when you have a chance to digest that little semantic point.
I mean, if I'm gonna play this game, right? If I'm gonna give that much emphasis to it, if I'm gonna play this game, I better be willing to follow it all the way through, right? So, or I gotta change the game. So, like, I gotta play with that and see if I'm willing to, something's got to give somewhere. It's like, well, do I want to play this game further down? What's the consequences of that? Or do I want to change the game? What's the consequences of that?
That was the one thing of your analysis that frustrated me, and I prefer to talk it out with you than to just be frustrated.
It's a very, what would we say? A very geeky point of frustration, though.
Yeah, well, I am a lawyer, so
I appreciate that.
That's what we signed up for.
I appreciate that, man. That's hardcore. I like it. The other author says 2A. We read that one. Okay. Isabel says, are gun licenses unconstitutional? I don't know. Is a tax stamp fee for owning machine guns unconstitutional? I don't know. This is where we have to get into the question of, like, what qualifies it as an infringement. Now, if we're in a First Amendment context, which is where I normally go to answer these kinds of questions, because I think the Second Amendment and First Amendment are more parallel than my friend over here. But because I think they're more parallel, I can cheat and I can use the First Amendment as a friend. So I would say, for example, the tax fee, I'd say yes, because we don't allow specialized taxes in a First Amendment context. You can tax newspapers the same as everything. You just can't have a special tax for newspapers, absent, so you need to basically show some sort of, like, elevated reason. So my initial gut answer is yes. Our gun license is unconstitutional. Again, we have to get into what the nature of an infringement is. And I don't know enough to know for sure. I think, let me put it this way. If we had shall issue permits for everything, and it's like, because, I mean, for example, in the First Amendment context, at least, you can make someone fill out forms to, like, do a parade or, like, reserve.
I was thinking parades or, you know.
So even to exercise your First Amendment rights, in some cases, you have to file some paperwork. So as long as the paperwork is, like, as long as you check the boxes, this is not overly onerous and stuff, yeah, it's probably lawful. It'd be my first gut answer.
If it were shall issue and it was not a prohibitive fee,
yeah,
I think that's probably
if it's just enough, it would have to be enough to actually justify the cost of it. So it would have to be enough to actually justify the cost of the background checks and the maintainings of the system and blah 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 blah, but not more than that.
The police to make sure security and order is maintained. I can.
That's probably fine. That's my first answer on that. Q squared said that would be narrower than A. A encompasses that which is not yet known more completely than the. The could mean a singular establishment. I think that's what I was saying.
I think that is basically what you were saying.
Daniel said, thought experiment. Can one within these rights carry a biological weapon, even if the weapon is illegal by law? See, I don't think it extends to biological weapons for the reasons I talked about. I don't think it's within the concept of the right to bear arms. I don't think it's within the delineated boundaries, so I don't have this problem.
I think that it speaks about firearms. The issue is kinetic weapons, period. I don't think that it extends.
It talks about arms, so
biological
probably extends to knives and stuff like that, but yeah, they can.
Again, knives are still kinetic weapons.
I guess. Matthew Hagen says this conversation is great. Thanks for the interesting discussion. You're welcome. I like interesting discussions. I like learning. All right, so that's going to bring us to the end of our day. John kicks ass. because
Thank
John can play with me in my sandbox, and I like it when people join me in my sandbox to play. It's nice to have friends.
I enjoy it. It's a lot of fun.
All right. I'm going to have some food, and then I'm going to go to sleep, and I'm going to do it all over again tomorrow. I will talk to you all later. Until later, my friends, I've been on Uncivil Law. Please remember to subscribe. And John, how can they find you on the interwebs?
Just right now, the Twitter. I still have to set up the YouTube, but I'll get there.
Don't do it. It's a trap, John. I'll talk to you later.
I have fun.
All right,
Take
bye-bye.
care, guys.